Adjournment request, if any, from item number 1 to 6. From item number 7 to 16.
May I please, Lordship? Lordship, I beg to mention item number 6. As some instructions from the party is to be taken.
In fact, you have to take steps for service of notice upon two respondents.
Lordship, some instructions to be taken from the party. That's why today we want adjourn.
Want to withdraw or what?
Uh,
Otherwise, you have to take the steps.
Lordship, we are going to take the steps but for today, we are taking the adjournment.
Passing, it's a formal order. You pass, let the number. Let the number come that way.
Highly obliged.
Item number 7 to 16.
My pleasure. Lordship, I beg to mention item number 11, Lordship, with the consent of the other side, Lordship. Then matter may be posted on
You are applying for?
adjourn
For whom?
appellant notice.
Applicant.
Appellant,
This commissioner and secretary.
Lordship.
I'm for the respondent, Lord.
January.
Lordship, a date may be fixed kindly.
Ask the report part.
Obliged.
9th January.
That is Lordship. With the consent of other side, I beg to mention item number 10, Lordship.
Item number 10,
Yes, Lordship.
interest on dues. Where are the dues? They already paid you.
Lordship, for day, for today, Lordship. Scenery suffering from people, Lordship.
Pass over for the day.
Obliged, Lordship.
Pass over for.
May I please your lordships? Lordship, I beg to mention item number 16 in the consent from other side, lordship.
Item number
16, 16, lordship.
16.
Lordship, we need some time to file additional affidavit, lordship.
You were supposed to satisfy the court
Yes, lordship, conducting.
on 29th of September, I think so. We have directed you to satisfy the court. That why you have not, in whose interest you have filed this PIL petition.
Yes,
And how those persons are incapable to approach the court.
yes, lordship. In that regard, we need some time to file additional. affidavit.
16.
Then 3 months, if they have not been able to satisfy the court, then what remains in this?
Lordship, actually, Mr. Deputy Bora Conducting Council is not present.
In fact, July may we have passed this order, not on September. Concept of the. Mr. So-and-so for, so-and-so the concept of the petitioner plays for some more time to satisfy the court about the query. Please, my order dated 29/7/2024. This can be very. Yes,
Obliged, lordship.
From item number 17 to 25.
I believe the Lordship. In item number 23, Lordship. Lordship may not like to take up the matter. 23, Lord.
another bench. Yes,
Lordship, in item number 18, lordship, I am for the respond number 7, 8, 10, 12, 13, and 15, lordship.
item number
18, lordship. So we seek some more time to file our affidavit, lordship. I have taken the consent of the petitioner,
Irregularities in mutation.
lordship.
There is a procedure,
No, lordship, I am for the respondent.
you are for the respondent, you are for the petitioner.
I will
How
be
this PIL is maintainable when the other remedy is already available? Challenge those mutation proceedings before the revenue court or the, whatever the forum is provided.
Lordship, today they are seeking time to file affidavit. Let the
Next
affidavit
week.
come.
Lordship,
Not more than that.
lordship.
My lord, I will actually allow item number 7, my lord.
Item number
7, my lord.
17.
Only 7, your lord.
Seven.
Affidavit ready with you.
Ma'am, it's a formal order we have to pass and formal order, nothing else.
Affidavit ready for hearing, my lord.
You are appearing for,
Section number 1, 5 and 6.
you are supposed to file,
Affidavit.
counter.
Yes, your lord.
So
Yes.
why you have not filed? Earlier also we granted you time.
Lord, ready for hearing, my lord. I may be allowed to file today only. Please.
You are
It is
filing
ready for
objection
me.
today,
Yeah, my lord.
1 week. Yes,
May I call the lordship, item number 20, adjourn for the day, lordship.
item number
20. 20.
20.
Yes, that. Consent from other side, lordship.
Consent and get the order from other side also. Drafted order with the consent and give it to us. We'll sign it.
Consent from other side, lordship.
It weeks.
From item number 26 to 35. 36. My lord, I'm appearing for the state, my lord. I'm mentioning item number 27, 28, 29. We are supposed to file an affidavit, my lord. My lord, there are some developments. This is regarding my lord, the delimitation of missing autonomous council. My lord, there are some developments. So, my lord, developments, my lord, government is contemplating, my lord, in a process. to-
Grievances.
Yes, grievances, means taking out all those. We are now, my lord, verifying those villages, population, everything, my lord.
So still final notification is not.
No, nothing, my lord. So, my lord, we are seeking 4 weeks time. We have taken consent.
Learned council appearing for the state. You are for the state.
Yes, my lord.
And council appearing for the state of Assam submitted that the state government is considering the objections regarding the delimitation process of the missing autonomous concept raised by the petitioners in this petition. Therefore, some time may be granted.
I'm appearing for a petitioner lordship. May I pray for fixing a date after vacation lordship?
My lord,
After-
Subject to your committee.
let it, madam, after 4 weeks, my lord, after 4 weeks.
Personally,
Yes.
You have the above is this matter of the. Yes.
6 February.
May appeal lordship. With consent to the other side, my lord, I beg to mention item number 32, my lord.
3-2.
Yes, my
It's
lord.
a hearing matter.
Yes, my lord. Miss, conducting counsel, Mr. V. Pathak is out of station, my lord. So this matter may be taken after 1 week.
This matter, lordship, I am for the petitioner, lordship, there is some urgency in this matter, lordship, your lordship has directed to bring the record.
Agreed for adjournment.
Yes,
The
lordship,
urgency is there.
but lordship may kindly fix a date, lordship.
Why you have agreed for adjournment if urgency is
Lordship, since he is not present also,
after a week?
My lord, much availed, lordship.
lordship may fix a date, lordship.
January.
January may, then fix it in January.
Item number 36, my lord, today's list, my lord, I have instruction to withdraw this petition.
Which one?
36, my lord, hearing matter.
36, wants to withdraw, dismiss and withdrawn.
Item number 30, lordship, I am the petitioner in person and I have received the affidavit in opposition. I am going to file the reply.
Thank you, and the council, the petitioner in person has submitted that he is in receipt
Right.
of counter affidavit on behalf of the state. And, state, he takes some time to file. Rejoin the. This after.
Can I pray for a date, lordship? Because affidavit ready, I am going to file it tomorrow.
Yes.
My lord, I'm mentioning item number 21. In this case, respondent has filed affidavit. So lordship may kindly allow 2 weeks time for filing the counsel.
Ritam Singh,
Yes, my lord.
you are appearing for whom?
Lordship, I'm
Petitioner.
for state, my lord, since the counsel of the case is up to station, that's why I'm mentioning all of.
February. But the request of the. February.
5th of February.
Yes.
Any other request?
Lordship, I'm praying for listing of a review petition, my lord. We filed it on second. It is also registered, my lord. So can it be taken up, my lord, day after tomorrow? Because we have,
Next week,
my lord, we have to hand over fishery, my lord.
next week. If you in the pen. When the order was passed.
29/11, my lord. We filed it on second review. Because, my lord, as per the order, we have to hand over the fishery to the another party, my lord.
If you don't hand over, we'll see to it.
Kindly, this week,
Next
my-
week.
this
yes.
week. Much obliged.
Daily list for orders item 1.
No, no, service reports not received, lordship.
Return of notice of respondent number 6 for
No.
3 more weeks.
Lordship.
Item 2.
You have not taken any steps for.
My lord, they have left the place, my lord, so I'm not getting the petitioner could not collect that. My lord, that, they may be the strike of my lord. That 11 and 12.
12 and 13, sir. Despite time granted by sir, no fresh steps or service of notice upon the respondent number 12 and 13.
Yes, yes, 12 and 13, my lord. They will strike of mine, they will strike.
Yeah, despite granting opportunity to the applicants for getting the notices of this application served upon respondent number 12 and 13, no steps have been taken. Today, Learned Counsel appearing for the applicant has submitted that the respondent number 12 and 13 may the respondent, the names of the respondent number 12 and 13 may be strike off from the array of the respondents. Well, in view of the submission of the Learned Counsel for the applicant, the respondent names of the respondent number 12 and 13 be strike off from the array of the respondents at the risk of the applicant. So, amended cost type will be filed within a period of
1 week.
1 week. This application in the month of January.
Obliged.
Item 3.
Wait, please, your lordship. My lord, pursuant to your lordship direction, you have taken justice service and they have entered appearance.
You are referring for
Respondent number 1,
respondent number 1.
lordship.
And what about other respondents?
Their state respondents, they have entered appearance.
They have already.
Yeah, I humbly pray that matter may be taken up for admission hearing sometimes in the new year.
Also put an appearance on behalf of the respondent number 1. Services, other respondents, are represented. Their consent services, their. This is for admission, month of January.
Deeply obliged.
Obliged.
Item 4.
Office note indicates that neither AD card nor answer notice is dated.
Take fresh steps.
Lordship, we have taken steps twice. Lordship may be directed us to take up in paper publication. Lordship.
The paper publication, I can send the register for what happened to that.
No, Lordship, 3 times we have taken steps, but all the time they have not received neither.
What is whether that registered post is returned back with the.
No,
acknowledgement
no,
or not?
Lordship. Office note indicates that nothing has written.
Sent it by registered post until I understand that all the means are exhausted. That doesn't mean.
Okay, I'll take this step.
Okay. The notices issued to the sole respondent has not been served since long. And a consent for the applicant is directed to take fresh steps for service of notice upon the sole respondent registered post in daily
Lordship.
within a period of 1 week on taking such steps, let notices be issued to the respondent number,
Sole respondent.
sole respondent, returnable 6 weeks thereafter.
Much.
Item 5.
My lord, is a contempt petition, my lord. The operative portion is at page 20, my lord.
Notice, remember. It is registered in
Right.
Item number 6.
you have to take steps for service of notice upon the respondent number, the respondents.
Yes, lordship.
As per the office report.
The steps are not yet to be taken, and there is some questions of maintainability also in the probably. So the engaged counsel, he is out of station, so he just asks for some time so that we can take the steps.
It's not on them.
Yes, Lordship.
It's not shown for along with- It's not shown for along with the. It's a list on.
Highly obliged.
Verify 17, 12. 17, 12. Article. Please, put the- On 17-12. 17-12.
17.
Item number 8.
Lordship, I am sorry, it's somehow left out. Lordship, I'll take,
You have not taken any steps.
yes, Lordship, I'll take by on the course of the day to day.
Okay. As per the office report, no steps have been taken for service of notice upon the respondent number 12. Learned Counsel undertakes to take steps during the
Course of the day.
such steps during the course of the day. List are monthly.
Deeply.
Item 9.
What is delayed, my lord? This is application for. Appellants.
I am for respondent number, my lord, Seba 2.
Paragraph.
Respondent number 2,
Yes, my lord.
Director General of Police.
No, Lord, Secretary, Board of Secondary Education. Nine two. Oh, sorry, my lord. Sorry, my lord, it is not my matter.
Yes, who is appearing for the? You're appearing for what?
Someone is still responding.
All the respondents are police recruitment board and district level police recruitment. You're appearing for all the respondents?
Yes, ma'am.
So what do you want to say? R.K. Bora learned appearance, accept notice on behalf of all the respondents, you have accepted it. Yes, what do you want to say?
Let him, my lord, delay may be controlled, sir, let the matter.
Okay, the matter comes upon for consideration of the application. Referred on behalf of the applicant. Under section 5, the limitation has been clear to promote the period of 71 days in present day. Completed appeal. Mr. R.K. Bora, the government advocate is appearing on behalf of all the respondents who were held not seriously opposed application. Hence, the application is allowed delay of 71 days in filing the connected appeal is condoned. Registry is directed to register the connected appeal and place it before this court for admission after May
Like
8th of January.
For admission, item 12.
For this writ appeal, I may prefer against the judgment of the single judge by my claim for the promissory estoppel, doctor and promissory estoppel. Lord, I established the industrial unit on the basis of the 2007,
That provision
my lord.
says that this subsidy would be paid from the date of commencement of the production.
Well, because that means because without commencement of production, the question of the transport subsidy will not arise at all.
There is that.
My lord, transport subsidy scheme, you also will see. Given a page. You also may see the. Policy, first of all, you also will find.
Because the learned single judge has decided this as ruled against you on the ground that since you have not started the commercial production till the currency of the scheme and therefore you are not entitled for that.
Well, I just went on, if you also permit me, you know, the transport subsidy was to be entitled from the date of the commencement of the production. There's no dispute about it.
Fine.
Now, the
Your argument is that he's and whatever the beneficiary is entitled to get the subsidy from the date of commercial, this commercial production. But that doesn't mean that he is only entitled for the subsidy until and unless he started commercial production before the current, during the currency of the scheme.
my lordship is aware
The promise stopper is the one who takes the steps on the basis of the promise.
Asking, where is that rule?
Scheme, transport subsidy scheme. Additional personal. But also estimate price 32. If you run- If you need hotel. So that is at phase 82. Velocity 3. Page 82, my lord.
Page
82, my lord.
This is the scheme.
Transport subsidy scheme, my lord. And clause 3, your lordship may see,
Clause B.
my lord.
Next to any APP doesn't extend product number 14.
The whole issue which is arising for consideration for lordship that, my lord. Well, Lanesh Singhal just said that the promise was conditional on the commencement of production. But the promise was not conditional. The promise was that you will be entitled to transport subsidy, but from the date of the commencement of the production. Naturally, my lord, unless and until the commencement production is there. Well, assuming, my lord, for the argument's sake.
Plain reading of this clause 3, it appears that this, it is applicable means this scheme is applicable to the industrial units for a period of 5 years from the date of commencement of the commercial production. And nowhere says that he will get benefit from the date of commencement of commercial.
Well, otherwise, my lord, just my lord, the transport subsidy in on the transportation of the finished production raw materials. Unless and until the commencement of production starts, the question of the transportation of the finished production raw material will not arise at all. Now, your lordship may kindly appreciate one thing, my lord, that I established my industrial unit. My industrial unit was ready on the basis of the promise that I will be entitled to transport subsidy. Before the commencement of production, one day before, the transport subsidy scheme is withdrawn. Will it not mean that a promise which was made to me, they are resigning from the promise, my lord, the judgments of the apex court are that, my lord, if anybody takes any steps on the basis of the promises made by any authority, my lord, then that promise, they cannot be allowed to reside from the promise because the person cannot be put back, status cannot be changed to the earlier one. At this stage, there is no prayer for any stay. I think this needs. But the period of 5 years is for calculation of the transport subsidy, my lord. That from which date, how much amount you will entitled to. But that doesn't mean, my lord, the promise is only from that date. Otherwise, my lord, no case, the promise will fulfill. Anybody can withdraw it before one day.
And for that, Learning Singhal, they just taken aid of certain Supreme Court judgments.
My lord, my Supreme Court judgment have not been taken care of. I've given 20.
No,
the-
some judgments have also been
My lord,
considered.
well, one or two judgments, but the Supreme Court judgment, as you lost here, Motilal Padampat was the first one. When it says the change of policy will not allow the state to take away the accrued and vested rights of the petitioners.
But in the subsequent judgment, some.
My lord, unique and was the altogether different. There the act was, my lord, there was a VAT Act and the GST Act came to force. So the Supreme Court said when the legislature has changed the scheme itself, and here there is no change of the scheme. The transport subsidy scheme, the
Scheme, the scheme came to an end.
no, the scheme was continuing.
It was only for 5 years.
No, my lord, 5 years only for a particular person. The scheme was continuing. They came up with a new scheme, freight subsidy scheme in 2013. My lord, this scheme is only that person will be entitled for 5 years from the date of the commencement of the production. 2007 policy, my lord.
Yes.
The lordship scheme has been extended time to time. Now, lordship, only thing is that lordship, this promissory estoppel, my lord, senior friend was arguing. Lordship, promissory estoppel is not unfettered, right? Actually, the promise is like, promise has been given, provided you fulfill certain conditions. And the first condition is that like, you'll have to come for commercial production. If you set up your unit, but you do not go for commercial production, you don't get it. Now, lordship, this policy was changed. This scheme was changed, replaced by another scheme because of certain reasons. And that rights, but the government has the right to change the policy.
This policy was changed since when?
It was changed from 2013, your lordship. So 2013, another scheme came.
Date exact 22.
31/3/2013.
22-1, no?
21.
31/3/2013.
22-1.
And this,
22, lordship, I'm sorry, 2022/1/2013.
My lord, I think my learned friend is defending it, but he's not the framer of the scheme. It is Union of India. He's appearing on the state of Assam, and state of Assam is,
Yeah, lordship.
Here for assistance.
no, I assist and I'm saying, my lord, but actually the Union of
I'm
India.
assisting the court only.
No, Union of India should come up and, my lord,
Yes. Now,
I'm not objection at all.
Lordship, one more
22nd of January 2013.
13,
Policy came in,
new scheme.
new scheme.
Yes, lordship.
Now this, this appellant was registered when that earlier policy, though commencement of this commercial production was on a later date.
Yes, lordship, what has happened is that they have come for commercial production on 31/1/2013. So they missed the bus. Now, whatever.
31st of March,
Yes,
started commercial production on
31/1/2013. So only few days, lordship, that is correct. Because this new scheme, the new scheme has come on 22/1/2013. And therein, lordship, this fly as like that they are claiming for that has been put in the negative list. So they actually they missed the bus. Now, another thing is that, lordship, the plea that they have taken is that their unit was already ready. But because of some electricity connections.
That is not the plea, I think, so Leonard Singhal.
Yes, he has.
Then this Assam, this
Yeah,
power
NPCL
distribution company was also not party.
Not party to it. That's what I wanted to mention. Lordship, there was not made a party, but that was one of the ground they have taken, and they have not brought in any material on record to show that like electricity line was given later.
No.
That argument, maybe we may not consider.
Yes, lordship, yes, lordship. But lordship, as far as lordship, as far as lordship, that new scheme is concerned, lordship, that power has been given to the central government, and central government come with a new scheme under the policy of NEIPP.
And earlier it was with the state government.
Now, earlier one also it was with
Central government.
Central government earlier. The only thing is that lordship promise whether the promissory estoppel will come into this effect, because they have already missed the bus. The promises lordship has been made to the units which have come into commercial production within the active. Yes, that period, but they have not come into commercial production within that
Who is
period.
appearing for the Union of India?
Union of India, Lordship, earlier Lordship, R.K.D. Chaudhary was appearing, now Lordship,
Learned council for the.
Well, I was registered under the transport subsidy scheme type 1971.
Council, the. Look, that they failed to take into consideration. That then. For the purpose of. Availing. The subsidy. On transport,
transport subsidy.
transport subsidy. The essential condition. Is that. The. Unit. Shall register itself. During the currency of the scheme. However. The. Commercial production. Commencement of the commercial production by the unit. Is not the essential condition. For getting. For availing the benefit of transport subsidy. It is. Submitted that the learned single judge. Has. Concluded that since the appellant unit has not started the commercial production during the currency of the. Transport subsidy scheme 1971. It is not entitled for the transport, it is not entitled to avail the transport subsidy. Good stop.
Just a minute, I was registered, page 143. If you also see, page 143, if you also see,
Yes,
that I was registered under transport subsidy scheme 1971.
is submitted that it is not in dispute that the appellant unit was registered under the scheme of 71 during the currency of the said scheme. Per contra, the net council appearing for the year for
Under the state Lordship, this one number,
of Assam
yes,
has submitted that since the appellant unit has started commercial production after the scheme of 1971
was taken off. Was taken off,
Huh?
was taken off, 1971 scheme was taken off,
After the framing of the new
Yes.
scheme.
correct,
The-
I'm sorry.
After the scheme of 1971 was over and a new scheme was introduced by the central government. Therefore, the learned single has not committed any iniquity in refusing to grant relief of subsidy, refusing to grant relief to the appellant. Full stop. Having heard the learned counsel for the parties, we are of the view that matter requires consideration, hence admit issue notice. The so and so, Mr. Pandita, accept notice on behalf of,
3 and 5 Lordship,
they have already issued the notices.
that was on the IA Lordship, there was a delay.
That was issued notices to the other respondents, returnable. 6 weeks registered AD, trustee.
Okay.
You just please, note it down to the board master. The remaining respondents.
Yes, yes. It will be provided. So if your lordship permit me, the Union of India, this, I can send the copy to them, registered post.
The appellant is also free to serve the copy of the, upon the standing council, on the additional.
Typing it there.
Phone number one.
You please, if there is other respondents are there, then get the notices to others, and otherwise, if all the respondents are there, noted that all the respondents have been represented, no need to issue formal notice. If someone is remaining, then get the notice.
We'll serve the extra copy. Lordship, I'm highly obliged.
Item 13.
Yes.
Well, as this appeal is directed against the judgment and order dated 22/10/2024, whereby the writ petition filed by the petitioner was dismissed, my lord. The matter pertains to change of date of birth, my lord. Well, at this stage, my lord, Lakshmi, be pleased to issue notice, my lord, we will not take
Please issue the notice. Convince us.
Yes, my lord,
Question of issuance of notice.
well, one of the grounds, my lord, why it was rejected was the fact that the Janam Kundli was never produced before the authority, although it was placed before the. Yes. The horoscope, the horoscope, my lord, when.
What is the authenticity of that horoscope or Janam Kundli?
Yes. And in fact, the principal of the school, my lord, in the.
Produce that Janam Kundli, have horoscope.
Yes, horoscope
Where
is.
is that?
My lords, the horoscope, my lords would find, Lordship would just give me a moment. It was produced before the honorable single judge also, my lords. I'll just place it. Just give me a moment.
88.
Page 88. my lord.
88. So it predicted what for the.
90. Page 90, my lords. It's in Assamese, my lord.
Yeah, you are comfortable with the Asmi? So what this astrologer has predicted for the Apala?
My lord,
Predicted is sure. Not only a date of birth.
yes.
Some predictions are also there. What they have predicted, whether they became true or not.
It predicts of a bright future, my lords.
What is this bright future? Of she is what? She is a teacher or what?
She's a officer with the sales tax, my lords.
Yes, yeah, that's right. She is having bright or she might have bright future. But what others, all the whatever the predictions are true in her life.
I'll have to take instructions on that, my lord.
Is there any mention is that that you will entangle in some legal battle or something to share the cover?
I'll take instructions.
It's a horoscope. The prediction is there. Is there any prediction that she'll enter into a legal battle with the state or any other else?
My lord, the other ground is, my lord, in the year 1984 itself, the principal of the school, after she passed HSLC, had.
When this was prepared, this horoscope was prepared.
That is not there. The date of the horoscope is not there.
Get it now prepared. Horoscope तो कभी भी बन सकता है.
I think that night. Nine, no? In the Janam Kundli, there is no death. My lord, may kindly turn to page 62 for a moment. Okay.
Nine. I know.
Yes,
My lords, may I also turn to page 62 for a moment, my lords? 62. Six.
yes.
Now, the original, my lords, would find at page 63. It's a letter by the headmaster, my lord, which is dated.
Which has been disputed by the headmaster itself.
Yes,
There is no record for this issuance of
The
this.
current headmaster, yes, but it was
So-
sent.
It is not there in the record. And the change of date of birth,
My lord,
first of all, it allows only clerical mistakes.
clerical mistake.
Secondly, has to be routed through particular authority.
The inspector of schools in this case.
Then here in this case, no such procedure has been followed.
But the letter says, my lords, it's through the inspector of schools, but it was not.
How he has come to this conclusion?
My lord.
There must be some evidence that yes, he is convinced that his date of birth, date of birth was wrong.
It does not appear from the letter. I mean, how did he come to that conclusion?
The learned single judge is considered each and every.
But in those times, perhaps, my lords, concerning date of birth, there were no, it's dependent on the principle of the school.
You're right.
My lord.
If the date of birth would be, suppose 1st of January
Yes, my lord.
or 31st of May, because it is common.
Mm.
Where the date of birth is not known, then normally if children goes to, parent goes to school, इसका date of birth क्या है? They don't know. Okay, write it 1st January.
Exactly.
Or at the time of opening of the school or the school session when it starts. So what is the date of birth? Okay, ठीक है, 5 years है, it's okay, then minimum age is 5 years, okay, 31st of May 2024, that is the common,
Yes,
at least in the north.
yes, yes.
Then we can deduct this is a guess and simply a guess,
Mm.
but here specific date is given.
Yes.
You say this date was not correct. And ultimately, what was the basis for giving this certificate to the headmaster? How he was convinced?
Maybe because of the Kundli, my lords, it was.
Huh? Ask your client कुंडली तो अच्छी बनवाते कोई और बड़ा कोई ऐसा उसमें लिखवाते कि वही she'll get this post here sales tax officer तो कोई बहुत नॉर्मल है कुंडली तो अच्छी बनवाते हैं close for orders.
Deeply obliged.
Item 14.
The Honorable Single Judge has taken a view as the melody term of the agreement had expired on 30/11/2022. So therefore, they were, the appellant was not in service and they were declined to exercise the melody 226. Now, my lord, that conclusion has, my lord, without going, my lord, into the order of appointment as well as the, my lord, the agreement, my lord.
Remedy lies somewhere else.
My lord.
File a damages, suit for damages or civil suit. I got the learned single judge has said.
My lord,
Where the contract.
no, in the
Where
fact,
the term of the contract is going to be extended.
Right.
And even though in a given case, if the relief is to be given, then only have to continue up to that date, the contract is existed. Not before not after that.
my lord, so far as the appointment order is concerned, my lord, that was, my lord, after due selection, and there is in one condition that.
Ultimately, it was a contractual
Yeah,
appointment.
contract, yes, my lord,
It
the
was extended, it was extended up to 30th of November 2022.
22.
Thereafter, it was not extended.
It was not extended, but there is no, my lord, provision in the agreement that if that can be discontinued, my lord.
That is no.
No, Lord, this, my lord,
And the contract itself is time bound.
no, it
There
is
is
not
no
time bound.
question of any other-
Therefore, my lord, what I am submitting, my lord, it is not time bound, my lord. It is, my lord, from the various clauses.
So they appoint the, whatever the extension order. This was up to a time.
No, my lord, that is not.
Then the land single, then this, finding of the land single.
Lordship will kindly find the appointment order, my lord, at page 55.
Lastly, it was extended up to what date?
Then,
Hereby is
yes,
extended was there.
the last agreement that I have, that was executed is at page 57. My lord,
57.
57. My lord, these agreement visualize, my lord,
7.
Lordship, my lord.
Yes.
Your Lordship.
Agreement between so and so.
Lordship.
Shall be subject to outcome of the pending disposal.
Clause 2, Lordship, may
Will
kindly.
automatically, this agreement will automatically lapse on 30th of November 2022.
2, the agreement lapses, my lord, not the appointment.
Now,
My lord,
what
the
is the-
clause 2,
This agreement, what is this agreement? Read the agreement.
my lord, this is pursuant to the appointment order, page 55.
Read the
Lordship,
agreement.
Lordship, my lord. This deed of agreement, my lord, the first part, Lordship can skip, my lord, there's clause 1. That on and since the execution of this agreement, the second part is shall act, finance and
These
account
the
officer.
party shall act as so and so officer under section so and so, subject to the continuation of the scheme. Subject to earlier termination either on the ground of uncertainty or medical arrangement of further. Those who have already attained the advantage of retirement 62 years may be it. However, they give it that the agreement shall be subject to the outcome of the control. This agreement will be.
So, my lord, this is up to the, my lord, subject to continuation of the scheme, or else, my lord, it is on termination, or, my lord, due to unsatisfactory performance. These two clauses are also, my lord, elaborately given this subsequently, my lord. The agreement only lapses, and then, my lord, will find, my lord, the clause 2. That makes it clear, my lord. The party of the second part shall remain in contract from the date of signing of this agreement. There is no, my lord, date, my lord, up to which, my lord. The party of this second part remain duty bound, carry out the works assigned by the first party in accordance with the duty chart of the respective component design said contract period as enclosed herewith. The party of the second part shall submit yearly progress report on timely implementation of activities in relation to the component. First party shall make proper assessment of the performance of the second party. The second party shall endeavor and strive to contribute towards the fullest achievement of the target, qualitative and quantitative, as said by the first party during the ongoing financial year. In case of any shortfall, the second party shall be duty bound to give specific reason, plausible explanation for the same, if first party seeks explanation for it. If the written explanation of the second party is found not satisfactory, the first party may ask to improve performance as well as to improve himself, herself for the forthcoming financial year in terms of the qualitative, quantitative achievement in his duties, or can discontinue the agreement henceforth, depending on the nature of underperformance or misreporting on committed attitude to work in mission mode. So, my lord, this assessment has to be, so far as the performance, that has to be, my lord, assessed, my lord.
Why don't we go to arbitrator? Arbitrator. Clause 12 of the agreement.
Lordship, is there, my lord, but this court, my lord, it will not be, my lord, efficacious as such, my lord.
There is a
Lordship,
agreement
Lord.
between the parties, efficacious, first of all.
It is, there, lordship,
the agreement.
lordship.
You should have objected to it.
Lordship, my lord. This court, my lord, the honorable single just considering the, my lord, the case, my lord, and the nature of the, my lord, facts and situation of the case.
Right now.
Lordship, my lord. In fact, my lord, these similar cases have been entertained by this court, my lord, and the orders have also been, my lord, passed, my lord, including, my lord, the recent decision in 2024 also, my lord, with regard to the Madhya Pradesh, my lord. Now, they can also terminate me, my lord, from the service, provided the, my lord, situation that arises with regard to the misconduct, etc., my lord. Now, what they say, my lord, by the impugn order, they simply, my lord, say that because of the lapse of the, my lord, period, this has been discontinued.
It is not segmented at all.
My lord, it is the foundation that has come, my lord, the matter was heard by the honorable single judge. And my lord, during the course of the, my lord, the hearing, it was revealed from the other side that the reason is something else. That order, your lordship, yes, my lord, that order, your lordship will kindly find, my lord.
Just show us in the order of the learned single, the reason is something else.
No, my lord, yes, I'll come to it. At page 108. 108, lordship, may kindly come to 108. Lordship, may skip to page 109.
Yeah.
My lord, the second paragraph, Mr. Circular Learned, so-and-so on behalf and submits that if the actual truth of the record are revealed through an affidavit, the same would not be in the interest of the petitioner. Therefore, he submit that as the contractual period has come to an end, the petitioner was released from his contractual employment. After hearing, after this, my lord, an affidavit has been filed. And what was, my lord, given in the first affidavit, in the first affidavit, it was simply, said that because of the lapse of the, my lord, period, it has been terminated. But in the second affidavit, it is said that they have made an inquiry committee was, my lord, set up. And pursuant to that, my lord, a so-called notice was also given to me. I have also submitted my reply. Then they have, my lord, passed
We
the.
can presume that taking into consideration overall facts and circumstances of the case, the respondents have taken a decision not to extend the contract.
My lord, the regulation also, my lord, there's also one regulation is there, my lord. The regulation also provides.
In this case, page 109, therefore, the honorable court, after hearing the counsel, the court is of the considered view that the respondent should file an additional affidavit explaining the details of the reasons for releasing the petitioner from his contractual employment. We do not want to make that order stigmatic, as Lordship has rightly said. We do not want that his future should be jeopardized. So we gave him a simplicity order of releasing him. Every year we release after due appraisal in this system. He was also released and he was involved with a very major financial transaction. All the schools were not getting the finances. It was going to his colleagues' bank account.
Having heard the concept of the case, admit. Since parties are concept, since the respondents are represented to concept, no need to issue formal requests.
Deeply obliged, Lordship.
Item 15.
Lordship, I got instruction from the petitioner. The petitioner has furnished me some documents which I left out earlier.
Furnish some
Furnished some documents,
documents.
yes, which were left out by him earlier.
Those documents were not produced before the tribunal. Then
No,
how
Your
do you
Lordship.
consider it, sir?
No, these documents, we did not annex those documents in our writ petition, Your Lordship. Those were the examination.
Your admission on your part. You've taken the money, you've paid the money, there is admission on your part.
Your Lordship,
Not like the money.
Your Lordship, I didn't take money, Your Lordship, from Ali Jahan Asgar. But your lordship, I was on gunpoint at the time, so being bound.
Have you filed any criminal case against that?
Yes, your lordship,
That
Hmm.
you are forced to give the money on gunpoint.
yes, your lordship,
Criminal complaint.
I have lost one complaint before Dispur police station. Your
Against
lordship,
whom?
there is an examination in chief of Mr.
Against whom?
Lester
Against whom?
against a unknown person. Till then, I didn't know that person who was taking money. I only came to know that his name was Ali Jahan Laskar. I lost the complaint dated 21/11/2016 before Dispur police station. But the FIR was not registered. It was taken as an intimation, your lordship. But later
That
on,
may be a separate incident. But you return the money when you return the money?
your lordship, I couldn't return any money because
It is the charge, man. It is one of the charge.
your lordship,
Where is the memo of charges?
Page number 70 to 106.
On page 75 of the paper book. Is charge number 6.
Yes, your lordship.
As per the documentary evidence, the MA Laskar officer surveyor has made an agreement on 24/2016 with the complainant Muhammad Ali Jahan Laskar at Dispur police station, has agreed to pay him 8 lakh rupees which was taken by him during Itna. Also handed over 4 checks in the presence of witnesses.
Yes, your lordship.
This is what your admission.
Your lordship, the petitioner admitted that he had made an agreement, but after he lodged the complaint against that.
What's the complaint? What's that complaint? Read the contents of the complaint.
Complaint is at present not at my hand, but at present I have only the examination in chief and cross examination during the inquiry.
What was the complaint you made before the police that who compelled you to pay this, enter into this agreement, or who compelled you to pay the amount?
Your lordship, that was not the fact. Actually, lordship, I was continually receiving some unknown threatening calls, some unknown persons demanding me of some huge amount of money and threatened to kill my family members also.
That may be a
After
separate
that-
incident.
No, your lordship, after that only, on 21/11/2016, I went to Dispur police station to lodge the complaint, but on 23rd November 2016, the police police came to my office and told me that one Ali Jahan Laskar had made a complaint against me, and they asked me to accompany with them to the police station. And later on going there, I come to know that Ali Jahan, this is the person Ali Jahan Laskar who made the complaint. And your lordship, after returning from the police station on 24/11/2000.
And it was not the ground before this tribunal. We are not convinced.
Your lordship, may I file an additional affidavit that examination in chief and the part of cross examination of and then in the petitioner and also of
That is
the
already
complainant?
recorded in detail, ma'am. That is there in the record itself. In the inquiry report, everything is recorded.
Yes, my lordship, the report is pretty clear.
Counsel. For the petitioner after arguing for some time. Please. Some more time to prepare. That is the matter. Last time also you took this time, again you are taking time. You're not convinced. I can come with some. Separate weeks.
Item 17.
Yes,
May I please, your lordships, I am petitioner in person in this case.
yes,
As per Article 23
yeah.
of Constitution of India, no person accused of any offence shall be compelled to become a witness against himself.
So how will he, by giving information
Yes,
to the police that this accident is committed, how you are giving evidence against yourself?
yes, if I give a written information to the magistrate or police,
Yeah,
it shall be used there. When I may be called for a witness, you have submitted this FIR. When I am going by riding a bus or car, if any accident is caused, then if any
you are
person,
informed. What's wrong with that? How it is going to be, how will say that you are compelled to give evidence against yourself?
if in future, maybe in,
That is from maybe, what do you mean by maybe? How it is,
police maybe become
that is
witness.
the duty of every citizen, that this commission of a congenital offences has to inform to the police. How you will say that amounts you to give evidence against yourself? You have to simply give the information.
No, I may be as a responsibility to help the injured person. If of accident. Yes,
That can't be.
any other parties also.
Whoever causes death of any person by rash and negligent driving of the vehicle not amounting to further and escape without reporting to the order by state soon after the incident shall be punished. Yes, that is there. So how it is giving you evidence against yourself?
At this stage, not giving evidence. But if any trial court call me as a witness,
Show us any law.
there's another ground is there, lordship.
What another ground?
Uh,
The only ground that this is value Article 23 of the Constitution of India, that's all.
Yes.
What is the another ground?
Another ground, the government of India has implemented the BNS from the first day of July.
Yeah.
Except section 106 subsection 2. There is a notification. Kindly peruse in page number 11, 12. 11 and 12.
So what is it?
In exercise of the powers conferred by subsection 2 of section of 1 of the Bharatiya Nyaya Samhita 2023, 45 of 2023, the central government hereby appoints the first day of July 2024 as the date on which the provisions of the said Samhita, except the provision of subsection 2 of section 106 shall came into force. But Assam Police is registering numbers of cases under this provision. One for example, an FIR is annexed here with. This is raised
How it gives you a right? This subsection 2 is still not,
and not implemented,
not given effect.
enforced, and not
Not
given.
given effect to, then how you are agreeing? How you are agreeing?
I am filing it for the general public, benefit of general public.
I mean, general public, how the general public is going to agree by this, when this provision itself is not come into force.
But section cases are registered and lordship, my humble prayer, stay may be given not to register any case. not to, direction may be given to the Assam
Yes.
police not to register any case,
New Act there.
still not in force. Hmm? Home affairs, law and justice.
Stop. PI petition is filed by the Commissioner. Issuing a direction. For challenging the validity of the subsection 2 of section 106 of Bharatiya Nyaya Sanhita 2023. So, it is contended by the, it is contended in the petition that the subsection 3 of section 106 of the Bharatiya Nyaya Sanhita BNS 2023 is in violation of Article 20 in bracket 3 of the Constitution of India, which provides that no person accused of any offense shall be complied to be witnessed against itself. Para. Please notice that the central government has issued a notification on 23rd of February 2024 in exercise of powers conferred by subsection 2 of section 1 of Bharatiya Nyaya Sanhita BNS 2023 and appointed the first of day of 2024 as the date on which the provisions of the BNS shall come into force. It is noticed that the notification specifically says that the provisions of the BNS except the provision of subsection 2, section 106 shall come into force from 1/7/2024. From the above notification, it is clear that the provisions of subsection 2 of section 106 of BNS has not come into force till date. In such circumstances, the challenge of the petitioner to the provisions of subsection 2 of section 106 of BNS 2023 is premature and therefore no relief. And therefore, the relief paid for the writ petition for declaring the provisions of subsection 2 of section 106 of BNS 2023 as unconstitutional, being violative of Article 20 in bracket 3 of the Constitution of India does not arise. Which stop. It is stated by the counsel for the petitioner that though the provisions of subsection 2 of section 106 of BNS 2023 have not come into force, but the Assam police is registering the cases under the said provision. The petitioner has produced a copy of the FIR registered by the police station Mukalama, which district it is? District Nalbari, Assam. Stating that the FIR has been registered under subsection 2 of section 106 of BNS on 2/9/2024 in one of the matter. We are of the view that if the police is registering the case under subsection 2 of section 106 of BNS, though it is not in force till date, the individual person against whom any such FIR is filed is free to avail appropriate remedy available to him either before the criminal court or before the competent court of law. However, the state of Assam, the Director General of the Police of State of Assam should take note of this fact and take effective steps and issue necessary direction to the police stations not to register the cases, criminal cases under any of the provision of the BNS, which has not come into force till date.
God bless.
The commissioner is free to place the copy of this copy of this order before the Director General of the Police Assam. You are free to.
Item 19.
Please, Lordship, my lord, in this case, my lord, private respondent file affidavit and accordingly I file affidavit in reply. But my lord, this case relates to setting up a brick kiln industry, my lord. Particularly, my lord, I would like to draw your lordship's kind consideration regarding paragraph 7 of my affidavit in reply, page 200, 7 and 8.
200.
Affidavit in reply, my lord. Page 200. Paragraph 7 and 8. Paragraph 7, my lord. It is absolutely false and baseless plea of the respondent that the land over which the brick kiln has been established was also converted to non-agricultural land by the Deputy Commissioner as per law. And thereafter, the ASO issued certificate on 6/8/28. To the best of the knowledge of the appellant's petitioners, the Deputy Commissioner Hailakandi has not yet been issued any order reclassifying the land in question to non-agricultural land, and to that effect, the respondent failed to produce any evidence or documents to substantiate their claim. It is a fact that the respondent's agricultural land in question is surrounded by the agricultural land of the petitioners or appellants and other co-farmers, which is evident from the trace map and other documents. My lord, I have endorsed the documents in our memo of appeal. In this regard, for the interest of justice, the Honorable Court would be pleased to direct the Deputy Commissioner Hailakandi as well as the PCB Assam to revisit the matter and to ascertain the veracity of the truth in the true perspective as to whether the land in question is agricultural land and or converted, reclassified into non-agricultural land in reality, and whether the land certificate said to have issued by ASO Hailakandi dated 6/8/18 is as per official direction of the Deputy Commissioner, my lord. Then paragraph 8, my lord. 7 and 8, my lord, I would like.
Yes, please.
Yes.
Paragraph 8, yes.
Yeah, the deponent begs to state that public hearing was not conducted through the local Gaon Panchayat. The residents of the village, the residents of the village have not conveyed their unequivocal consent. The communication dated 16/8/18, Annexure 9, page 162 of the memo of appeal was not issued by the villagers of the RK Rajeshwarpur Part 1. Only 9 interested persons expressed their interest in the sense that the setting up of brick kiln will generate their employment. The PCB, particularly the member secretary, PCB Assam, is the helping hand of the respondent, my lord. The appellants again submitted representation on 3/1/23, but the respondent PCB Assam, without considering the grievance of the local villagers, farmers group, issued consent to operate on 3/1/23 and subsequently on 10/4/23 and 6/8/24 up to 31st of March 25. My lord, my respectful submission before your lordship is, my lord, the land has not been reclassified. The ASO, the certificate issued by the ASO is doubtful, my lord. My lord, he has managed all the certificates, my lord. My lord, in this aspect, I would like to draw your lordship intervention regarding order, impugn order passed by the learned single judge. Page 35 of the memo of appeal, my lord. The view of the learned single judge is
Yes, sir.
my lord, the view of the learned single judge is from the certificate issued by the respondents and the facts and circumstances stated therein, there is no reason to hold that the consent to establish and consent to operate issued by the respondent authorities is illegal and not
This
in
consent
accordance
to
with law.
operate was issued when?
Consent to operate was first issued on, my lord, P1/23, and subsequently it has been extended from.
Here in this petition, you have challenged this, which consent to operate? In the writ petition before the learned single judge, you have challenged which order by which the consent to operate was granted.
My lord, at the time of filing writ petition,
Yes.
they issued only consent to establish. We have challenged
That is dated,
dated, my lord, 16, dated, my lord, 12/10/18.
18.
Yes,
You have challenged that.
yes, and during the pendency of the writ petition, the PCB issued consent to
Fine.
operate.
Have you challenged that order passed by the PCB?
My lord, yes, my lord, we have challenged this consent to establish and subsequent order, if any.
Where is that?
In
Okay,
our,
that-
in
that
our
was- That consent to operate was for how many years?
consent to operate, my lord, that has been extended up to 25/3/31st.
I mean, how many years?
1 year. 1 year, my lord, from time to time, that is from, firstly, my lord, it was up to March 23, no? Then, my lord, it has been extended, my lord, extended from
January
time.
2023.
Yes, my lord. My lord, first it was issued on, my lord, yes, 3/1/23. Then subsequently, that was up to 31st of March 2024. Then 10/4/23 and 6/8/24 and
Ma'am,
up to
Ma'am,
31st of March 25.
madam,
My-
please confine your arguments up to this.
Yes, my lord, my respectful
Should we
submission
can't-
is, yes,
We
my lord,
can't look into the subsequent orders.
now they have been operating, my lord, as per order of the
So,
PCB.
so the landed single judge has granted you a liberty. Come to para number 19.
19, yes, my lord, I'm
Para
going
number
to,
19
I'm
of
going
the
to that.
impugned judgment.
Yes, yes, my lord, I am
Come,
going to
come.
that. Page
Read.
35, I think, my lord. Yes, page 36. Paragraph 19. My lord, in addition to this, my lord, my
Read,
respectful,
ma'am.
yes, my lord, having held as above, it has been brought to the notice of this court that the consent to operate issued to the private respondent had expired on 31st of March 2023. And since it is lean season, the application for renewal of consent to operate would be considered only in the month of October 2023. If that be so, there cannot be any doubt about the fact that while renewing the consent to operate, the authorities in PCB would have to verify and record a satisfaction that the brick kiln of the private respondent fulfills all requirements of pollution standards as may be prescribed under the law before granting renewal. As such, the PCB can also consider objection, if any, filed by any affected party who could have a genuine grievances with regard to operation of the brick kiln in question. Paragraph 20. In view of the observations made above, both these writ petitions are disposed of by providing that the petitioner shall be at liberty to submit objection before the state PCB opposing the renewal of the consent to operate in favor of the private respondent, if so advised. And such objection is filed within 10 days. My lord, my respectful submission, since we have challenged,
Madam, whether you have filed this objection as directed by landed or granted liberty to you, have you appeared before the authorities concerned?
PCB.
Yeah.
My lord, because my lord,
Pursuant to the liberty
yes, my
granted
lord.
by the landed.
My
single judge,
respect-
have you filed your objection?
No, my
Or
lord. As
against the
because,
renewal?
we are agreed by this order, as because the PCB also accepted the certificates. Basically, we have challenged these certificates, non-agricultural certificate, that has not been converted till date into the land has not been converted. The land has not been converted as per rule, my lord, into non-agricultural land. So my respectful,
So the subsequent renewal order, have you challenged that?
no, my lord.
Why?
My respectful submission would be, in addition to PCB, we may be allowed to file any objection before the deputy commissioner also, along with the PCB, and both will verify our grievances as because
Who is going to pass an order, this the consent to order?
consent to operate,
Yeah,
PCB, my lord.
PCB, then why?
No, my lord, the land, no, my lord. Deputy commissioner has a important role as because the land has not been converted, my lord.
The procedure provided in the rules can't be diluted.
Well,
by
end
the
of
orders
justice-
of the court. When the district commissioner has no jurisdiction.
No,
or
end
has
of
no
justice will
business
be
to
made.
attend to it, how can we directly?
No, my lord, end of justice will be made if we are allowed to file any objection before the deputy commissioner along with PCB, and both will verify our grievances.
How
So
the
if,
Deputy commissioner will come into picture, ma'am.
my lord, deputy commissioner, my lord, my lord, paragraph 65, lordship may kindly look into, my lord. Paragraph, my lord. Page 65 of my memo of appeal, my lord, lordship may kindly
What was the,
look into the non-agricultural land
Ms. Counsel,
certificate.
what was the difficulty for you to file an objection and take all this ground before the PCB?
Well, our,
Is directed by the
my lord,
single judge?
PCB is interested with the private respondent. Well,
You could have taken the objection, and if your
no, my lord, we
objections
we
were
will not get
considered,
justice,
you
my
could
lord.
have come
It
before
it
this
is
court
our
again.
impression that we will not get justice if we file in, as because numerous representations we have filed before the deputy commissioner and before the PCB, but
That is
they
the
will,
perception
they have
you are
not been
holding, and how
considered
can the
our,
court help you?
they have not been considered our representations, but that's why, my lord, we are before your lordship, my lord. That's why we are before your lordship, my lord.
Yes.
So, my lord, paragraph, page 65 of the memo of appeal, it is a non-agricultural certificate. I will quote the contention certified that land measuring an area 8 because so and so, covered by Dag number so and so, periodic quarter number so and so, in the district of Hailakandi is under possession of Subir Modak, son of so and so, Paragana by right of purchase. The above land in question is not presently being utilized non-agricultural purpose. So reclassification of the land will be done as wasteland or vita land or body, etc., in due course of third resettlement operation as per procedure, as reported by the LR staff dated 6/8/18 and valid for the purpose of establishment of baking industry. That land has not been reclassified till date, my lord. At the time of issuing notice by this honorable court, lordship asked me one question, whether the land has been converted into non-agricultural land. No, that's why notice was issued. Now our question is this, the respondent said that the land has been reclassified as per law. That has not been reclassified as per law. They failed to produce any document. And in similar situation, the circle officer, Katlisara Revenue Circle, he stopped the permanent construction of brick kiln as because that was established over the agricultural land. So my respectful submission is this. If we allowed to file any objection before the deputy commissioner as well as PCB, and they will jointly verify our grievances. And if there is any, if the grievance is not tenable, then we have nothing to make any grievances.
I am for the private respondent, my lord. Here in this case, my lord, this question, regarding non-agriculture and agriculture, this point has been raised before the learned single judge also. But that was not the main question. Main question whether the establishment of the breaking is in order or not. And that has been not entertained by the learned single judge, only said that consent to operate. In the consent to operate, he can file objection. Then thereafter, 2 consecutive years, my consent to operate has been extended after hearing me, as well as after considering the all relevant factors for passing the consent to operate. And that 2 orders, 24 and 25, till 25, it has not been, never been challenged. Nothing has been done.
I file miscase, my lord.
It is not in under challenge, neither before the learned single judge nor
Single judge, there is no question of challenging before the learned single judge because those orders were passed subsequently.
yes. And it is not under challenge, my lord.
My lord, I have challenged the paragraph,
So, how
page 112, my lord. I file miscase. I file IA against the consent to operate, my lord. Page 112, my lord, that is the miscase. IA number 171, my lord, we have challenged before the learned single judge, my lord. Page 112. We have challenged, my lord. And by photograph also. My lord, so my lord, my submission would be for the ends of justice, deputy commissioner may also be directed to inquire the matter along with PCB. We may be allowed to file allegations before the PCB as well as the deputy commissioner also. That's because land has not been reclassified. So what will be the harm if the deputy commissioner is directed to inquire the matter? For the ends of justice, my lord. As because we inquired on matter, no such order has been passed by the deputy commissioner for conversion of land from agricultural to non-agricultural, my lord. Nothing, my lord. They cannot produce any document.
District commissioner is party here.
Yes, yes.
Where is that?
Yes, deputy commissioner 4, my lord. That order may kindly be modified to that extent, my lord.
Those were orders.
ADC also filed a repeated in the petition.
My lord, if
Their grievances has been fully taken in.
any order is
Not a
passed,
reasonable order is in passed.
if any order is passed, my lord, if any direction is passed to the deputy commissioner, not in the level of ADC, my lord, we have no faith upon the ADC.
Consent to
ADC is very interested, my lord, with the private respondent.
Item 22.
May I plead your lordship? Lordship, in this matter, I am appearing for all the respondents. I need 3 weeks time to file our reply, lordship.
all the respondents?
Yes, Lord.
Sure.
Yes, Lord.
Tomorrow you'll come, I'm not appealing for all the respondents, I'm appealing only for these respondents. and then-
750.
There are 700 something.
759.
You find power on behalf of them. Yeah, what do you want to say? Yes,
You want
sir.
to, you want to say that?
Also there in this case.
So all the respondents are being represented now?
No, Mizoram University, we are not responding.
Huh?
Mizoram University, University of Mizoram.
Altogether thing, private respondent.
Yes.
Private respondents.
Okay, council appealing for the private respondents.
755. 755.
754.
755. 755.
754. Place some time to file. Time to do the. Time paid for his matter. Which matter? Yes, Mr. Council.
Item 24.
Lordship, in this case, inspection away, I pray for 2 weeks time, Lordship.
My lord.
Last time we asked you. When the person is in the same organization, posted in some different unit, how can you deny?
Lordship, let us explain that through an affidavit. I pray for 2 weeks time, Lordship.
So check it out. Wait for the time to file. Council to take something. And also to produce the relevant report before this court. Which in January.
My lord. Keep your lord.
Item 25.
May I pray, your Lordship? On the last question, I have taken time to file an objection, Lordship, but I have been instructed, Lordship, there is no necessity to file any objection. I have been instructed.
You don't need to file objection.
No need to, Lord. Already. एक हफ्ता लग गया, बाद में करा दूंगा।
May it please your lordship. My lord, it raised on a very short campus. My lord, I am not challenging the entire judgment. But the part of the judgment is under challenge. Now, what, my lord, the honorable single judge has upheld, my lord, my provincialization. And thereby passed, my lord, consequential orders, directions, my lord, in para 55 and 56. Yes. If your lordship, my lord, please. Para 55, my lord.
Insofar.
Yes, my lord. Insofar as the petitioner in 4881, that is the appellant, my lord, is concerned, this court in WPC so-and-so not having interfered with the order of 26/6/23. This is the provincialization order, my lord. And by reckoning the conclusions as reached by the Director of Elementary Education, Assam therein, that the services of the petitioner is entitled to be so provincialized. This court hereby directs the Director of Elementary Education, Assam shall issue consequential orders towards provincializing the services of the petitioner herein with effect from 1/1/21, as was so done in case of provincialization of the services of other serving teachers of the said school with all consequential benefits to pay, seniority, etc. And if your lordship
You
also
are not
comes,
agreed by this part.
I am not agreed by this part, my lord. And if your lordship comes to the next part also, the honorable single judge further says, my lord, the Director of Elementary Education, Assam shall pass appropriate orders in terms of the above direction within a period of 45 days from the date of receipt of a certified copy of this order. And the petitioner in WBC 4881/23, that is the appellant, my lord, shall be authorized all his due service benefits as entitled on his provincialization being affected in terms of the direction passed herein above. My lord, I don't have any grievance in respect of these two paragraphs. My lord, what the honorable single judge has held, my lord, honorable single judge directed the respondent one to approach the tribunal.
That is that.
Yes,
Next para.
that your lordship will come to page, para 54, my lord.
54.
54, my lord. The same page 208, para 54.
Yeah.
The petitioner in WBC 4564/23, that is the respondent one, is directed to institute proceedings before the jurisdictional educational tribunal by invoking the provisions of section 19(2) of the said Act of 17 for establishing his claim for provincialization of his services in the said school within 29/24. The petitioner, in the event of instituting such proceeding, shall implead the respondent 9 and 10 in WBC 4564/23 as party respondents in such proceeding. I am 10, my lord. The jurisdictional educational tribunal shall, on proceedings being initiated before it by the petitioner in 4564/23 on or before 29/24, proceed with the adjudication of the matter and reach its independent conclusions therein without being swayed by the observations made herein above in this order. So, my lord, my respectful submission is the honorable single judge, my lord, has held that I am entitled to provincialization, number one. Honorable single judge, my lord, also refused to interfere with, my lord, the part of the order provincializing me. And at the same time, my lord, has directed the respondent one to institute, my lord, the proceedings before the educational tribunal and also implead me, my lord.
So even if suppose if the tribunal issued an order for provincializing his services,
My lord.
your this provincialization would be affected or not?
No, not affected.
Not at
Not affected at all. My lord, because the fray is between the respondent one and the 10. Respondent one and 10. Because admittedly, my lord, under the act, my lord, the provincialization is done from three subjects. One, science and maths, another language, my lord, and social studies. I belong to social study, and both of them, respondent one and 10, they belong, my lord, to language, my lord. Now, by the provincialization order, replacing respondent one, my lord, the respondent 10 has been brought in. 1 and 10, my lord, it is between 1 and 10.
Not between, not for your provincialization.
Absolutely, I am out of the
But you are
picture,
agreed
man.
by his provincialization.
So see, I have nothing to say.
Huh?
I have nothing. His provincialization different thing. His subject is different, lordship. My subject is different.
Absolutely, I'm asking for only that much, my lord. So that part of the honorable single judge direction, directing him to implead me also, my lord, that part may be interfered with, my lord, and your lordship will say my provincialization attained finality.
And this second writ appeal is by whom?
There is only one writ appeal, my lord. This is by me, my lord.
Is an I.
That was an IA.
That was the-
Yes, your lordship had passed an interim order already on 3/9/24. And in the garb of pendency of this writ appeal, the operative part, my lord, the consequential part of 55 is also not, my lord, implemented by the, my lord, the authorities concerned, saying the writ appeal is pending. So no consequential order is passed, my lord, by the responding authority in terms of 55, 54 and 55, my lord.
You have no objection in
No,
this.
As he has said, lordship, respondent number one.
What do you mean by as you are in the writ appeal as a respondent, whether you have any objection or not?
None,
As
sir.
he has said, then TK will say
Lordship.
something else that record a finding that this you are not entitled for provincialization of services, no will record this.
No,
Then,
no, the main section is respondent 1 and 10, lordship.
yes, you are a bit for Mr.
I appeal for the department.
What is your?
It should have been the liberty of the person concerned to meet the parties or approaches forum.
Your, who is appealing for this private respondent? Anybody is appealing?
Finance department.
Who is appealing for this private respondent?
He is appealing.
My lord, the service have been complete. The dusty has been served on them. I have filed an affidavit to that effect. And respondent 10, my lord, has chosen not to appear. My lord, my learned friend is appearing for respondent 1, who is the writ petitioner. And 10, my lord, basically he has chosen not to appear because perhaps he is, my lord, contemplating to contest there, my lord, with him. Respondent 10.
This writ appeal. It's by behalf of the appellant. Filling dated 1/8/2024 filed by the learned single judge in red petition number 488/2023 and 4564/2023. Only to the extent where the learned single judge, while granting liberty to the
Respondent one, madam.
petitioner who has filed writ petition number 4564/2023 and is implemented as respondent number one in this writ appeal to institute proceedings before the jurisdictional educational tribunal by invoking provisions of section 19 in bracket 2 of which act.
My lord, the Provincialization Act, my lord, this is known as, yes, my lord.
Name.
Yes, my lord. I'm naming it, my lord. It is the, it is, my lord,
Assam Education in bracket provincialization of services of teachers and reorganization of educational institutions in bracket close Act 2017 for establishing a scheme for provincialization of its services in the school concern within stipulated time. However, the learned single judge has also issued an action to the respondent number one herein to implead the appellant Abul Hussain as well as the respondent respondent number 10, Mohammed Safiul Haq. Safiul Haq as party respondent in such proceedings. And counsel for the appellant has submitted that as a matter of fact, the learned single judge by the impugned order has allowed the writ petition number 488/2023 filed on behalf of the appellant and has confirmed his regularization. Provincialization on the post of social
social science, my lord,
on the post of a teacher of social science,
/ social studies, my lord. Social studies / social science, my lord.
social studies slash science, and has also issued direction to the concern to the state respondents to issue consequential orders within 45 days from the date of the passing of the order. And it council has submitted that as a matter of fact, the respondent number, as a matter of fact, the dispute regarding the provincialization as a language teacher was in between the appellant number one herein and the respondent number one herein and the respondent number 10 herein, and there is no dispute about the provincialization of services of the appellant as teacher, as social science, social studies / science teacher. It is therefore submitted that the direction issued by the learned single judge in para number 54 of the impugned judgment to the appellant number, to the respondent number 1 herein to implead the appellant along with the respondent number 1 as party respondent before the educational tribunal is unwarranted, and the same may be interfered with. Full stop. Para. Learned counsel appearing for the respondent number 1 herein and the counsel appearing for the state respondents and the counsel appearing for the official respondents are also of the view that the directions issued by the learned single judge in para number 54 of the impugned judgment of directing to implead the appellant along with the respondent number 10 herein as party respondent are unwarranted because the actual dispute is between the respondent number 1 herein and the respondent number 10 herein in respect of provincialization of their services as language teacher. Stop. Despite service of notice upon the respondent number 1, respondent number 10 hearing, none has appeared on behalf of him. Stop. Taking into consideration the fact that the actual dispute is between the respondent number 1 herein and the respondent number 10 herein in respect of provincialization of their services as teacher of, as language teacher. It appears that the direction given by the learned single judge to the respondent number 1 herein to implead the appellant along with the respondent number 10 herein as party respondent before the educational tribunal are unnecessary and are unnecessary and unwarranted. Hence, the writ petition, that this writ appeal is allowed to the extent of directing the appellant number 1, the respondent number 1 hearing to implead the appellant also as party respondent before the educational tribunal are interfered with and the same are set aside. It's stop. We make it clear that except the the order passed by the learned single judge is interfered with only up to the extent as clarified above, and the other directions and the observations of the learned single judge in the impugned order are not interfered with. These observations will split up in the report.
My lord, only one line, my lord. My lord, the director shall now, my lord, comply with the consequential part of 56.
We have not interfered.
My lord, correct, correct. Obliged. Deeply obliged.
Item 26.
My lord, matter may be possible for the time being, your lordship.
I.
Yes,
For the time being, your lordship, senior is at court number 3.
the time.
Item 31.
My lord, here, my grievance was, my lord, that the compensation receivable by him in view of the land acquisition not having been quantified, my lord, the petitioner was unaware of the amount, my lord, to be received by him. Now, my lord, affidavit has been filed by the Deputy Commissioner, my lord, the Baihata, my lord, Bishwanath Chariali, and in para 10, my lord, this is relevant of their affidavit.
That some amount, has
Yes.
already been sanctioned.
Absolutely, my lord, that amount of 33, comma 59, 131, that is pending before, my lord, the competent authority, Kala. And the NHIDCL in its affidavit has also, my lord, made it clear that that amount has already been disbursed, my lord, to Kala. This amount is pending, my lord, before the, my lord, competent authority by Hata. That may be released now, my lord, to me, within a short period.
For that authority. Yes.
My lord, any grievances, my lord, according to the, my lord, National Highway Act, my lord, 3G.
There's no grievance.
Yes.
The money is already, that determined and deposited.
Yes, yes.
Sorry, a matter of release.
In,
There's no dispute about that. He is not asking for something else.
In respect of this, my lord, I have no dispute.
Please.
Yes, absolutely. Para 10 তোমালোকে লিখিছা 33 lakhs pending আছে আৰু NHIDCL লিখিছে amount is sent. Para 10 sir. Page 106. 33, 59, 131.
my lord, the balance remain 33 lakhs 59 131 to be paid to the petitioner, which was also awarded to the petitioner in due course. If that has not been disbursed to the petitioner, that can be given.
I have stated, my lord, in para, my lord, 7. Yes.
No, no, my language is, my lord, which was also awarded to the petitioner in due course.
Yes.
Awarded, my lord, only instruction is needed whether that has been disbursed or not, my lord. If not disburses,
Determined as per the order, this, which para you are reading?
my lord, page 106, my lord, of my affidavit, my lord.
Your affidavit.
Sure.
Now read.
Para 10, 105, my lord.
That with regard to the statement of the 21 answering respondent back to the authority concerned, again revise the compensation amount to the petitioner along with the other landowners and reassessment and revision. The petitioner was found to be entitled to receive a cumulative and consolidated amount of rupees 79 lakh something,
Yes, my lord.
including the amount of which has already been paid to the petitioner. And hence, after deducting the earlier amount from the so and so, the balance remained itna to be paid to the petitioner, which was awarded, which was also awarded. What do you mean by a?
Yes, 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 yes. Yes, yes.
That remaining, your admitted case is that 79 lakh something, 45.
33, yes.
Paid. This remaining amount is to be paid. So how many days you are going to pay? That's all. Not dispute about determination of that. You have already determined the methods of payment. By what time you, yes. You just sit down. You have already deposited amount. That's all. Thank you very much. Yes.
Let him file in representation in the due course.
But why representation? This is my right, my lord.
Just a minute.
No, let me clarify it. Let me clarify it, my lord. Let him file a representation within 2 weeks. Again, my matter may be listed.
Sir, this is your.
Yes, yes, yes.
affidavit.
Yes, yes, let
So
it.
why to file a representation? This is your admission of the affidavit. Again, you are relegating to him. Where is the question of sending him to, again ask him to give a representation?
Okay, my lord.
This is your own admission.
Yes. Let it come after 2 weeks, my lord. In the meantime, I'll accept the pay the remaining.
This petition is filed by the. appellant being agreed with the order dated 26/4/2024 passed by the London Single Judge in petition number 2193 of the 2023, whereby the London Single Judge has closed the writ petition without adjudication. While observing that the grievance raised by the appellant of insufficient land acquisition compensation can only be raised, can only be addressed by filing, but can only be addressed by availing the statutory remedy as prescribed under section 3 under section 3 in bracket 5 of the National Highways Act 1956. Learned counsel for the petitioner, appellant has submitted that as a matter of fact, the appellant has not raised grievance about the insufficient land acquisition compensation, but has approached the writ court only with the contention that the compensation determined by the authorities concerned has not been paid to him in full, and only a part payment is released. Good stop. It is noticed that in response to the writ appeal, an affidavit is filed on behalf of
Respondent 9, my lord.
Deputy Commissioner Vishwanath, in bracket presently District Commissioner Vishwanath, wherein in para number 10, it is specifically mentioned that the compensation required to be paid to the appellant in view of acquisition of his land is determined as 79,59,204 rupees 79,795,204. Hour out of the said amount 46,000,074 rupees 46,000,074 has already been paid to him, and the balance amount of rupees 3,359,131 is required to be paid to him in view of the specific admission made on behalf of the Deputy Commissioner Vishwanath, we are of the District Commissioner Vishwanath. We direct the counsel appearing for the Deputy Commissioner, the District Commissioner Vishwanath to instruct the District Commissioner Vishwanath to release the due amount to the appellant as admitted by it in the counter affidavit filed on 8th of November 2000. Within a period of
4 weeks.
4 weeks from today, list after showing for 4 weeks to ban the response showing.
Deeply obliged, my lord.
Supplementary list, item 37.
May it please, my lord. My lords, on the last occasion, the health department was asked to obtain the instructions regarding the medical examination, my lord.
Lordship, here I have received instructions.
You are appearing for the You are appearing for whom? Mr. Consul, you are appearing for whom?
My lords, I am appealing for the appellant, my lord.
Appellant.
Yes, my lord.
The matter, what happened on 8/12/2024? This, the next date before the learned single judge is?
18th of.
My lord, 18th. 18th December.
Learned single judge has not passed any order to provide appointment him to or whatever it may be. They have simply said, get his medical report verified from the concerned hospital, that's all. How you are?
Yes, my lords, that is why on the last occasion when the matter came up before, my lords, this court,
Yes.
they were supposed to seek instructions from the health department, my lords. Because this is the only point, my lords, if he is found.
Mr. Sharma, we are simply asking.
Yes, my lord.
How you are aggrieved by the order passed by the learned single judge?
My lords, on the simple point, my lords, that the learned single judge, my lords, had passed an earlier order saying that this matter will be disposed of at the stage of admission. And my lords, this was not heard on the merits. My lords, the simple point is that the rules have not been challenged. My rules prescribe that the.
Certainly. But the learned single judge, what the learned single judge has simply said, can get the petitioner be examined or the respondent be examined by the so and so authority. Still, he has not passed any order directing you to consider the same or to give appointment to him. Then how you are concerned?
My lord,
May I argue all these points before the learned single judge when, if suppose learned single judge proposed to pass any such order, sir? How this petition at this stage, simply they should is given, sir.
My lord, may I submit what the anxiety of the appellant is?
Yes.
My lords, there were 85 people, including my lord, 84 plus 1, 85 people who were non-suited, my lords, on this very simple ground of height and height. Only this one person.
Mr. Sharma, we understand that. But why you are inviting any observation from the division bench on this point? Now,
My lord, I am not seeking any observation.
It is always open for you to argue all these points before the learned single judge, and then in case any order adverse to is passed, then you can very well raise all these points. It is always open for you. Simply the learned single judge as an interim measure has directed to get in check. That's all.
My lords, may I make one submission? My lords, what I am aggrieved by today is that the setting up of the medical board also, in my respectful submission, my lord, is, my lords, without a challenge to the rules, with clear categorically say 10.30 of the rules, my lords, categorically says.
Mr. Sharma, appreciating your concern, what we are saying,
my lord.
if the learned single judge is simply now issued a direction that set up another medical board, which is as per you, is not in accordance with law and can't be done.
My lord, that is my respectful submission.
Suppose tomorrow learned single judge may convince by your argument that even though if I have directed this, but I can't take into consideration these facts, then he can take rule otherwise also. It is always why you are inviting any observation from the division bench? Why you are depriving why the airport authority is not ready to take opportunity before the learned single itself to argue on this point?
My lord, if my lords will be so kind to clarify this, my lords, we will go back before the single judge, my lord. The learned single judge. My lords, our only anxiety was that because the selection process is already over. So that was our problem, my lord. That is why we were before this court, my lord. Only for that reason.
First of all, Mr. Sharma, there is no need to clarify this aspect, although we'll try to explain it.
My lord, may I make one submission? My lords will kindly ask if the health department has already received instructions regarding the medical examination. If that has happened, my lord, all this controversy will be cut short.
Who is appealing for that?
Lordship, I am appealing, Lordship.
Yeah.
It has already been conducted, Lordship.
What about
the Lordship? It's Lordship. The eyesight is fine, Lordship. The height there is some, Lordship. We will produce the record, Lordship.
On the basis of whatever the examination you have conducted, whether this person is declared as a fit or not.
Lordship, I'm appealing for the private respondent, my lord. I'm appealing for the first time, my lord. I have been, I have filed my Vakalatama on Saturday, my lord. My lord, if I may be given a copy, my lord, and otherwise, my lord, as per my instructions, my lord, the learned single judge has given a, my lord, a judicious and logical, my lord, order because of the fact that, my lord, a court opinion was sought.
That is
So-
the learned single judge logical order, or whatever it
Yes.
may be, at present, we are concerned that it is always open for the Airport Authority of India Limited to raise all these concerns,
Yeah.
whatever they have raised in the writ appeal before the learned single judge at the time of final adjudication.
Absolutely.
Now simply, examination by a board is already given.
My lord.
But that may not, that may not itself is sufficient. That since the order is given, therefore that is to be taken into consideration. That can't be.
And my lord, since the Health Council has said that the examination is conducted, therefore the appeal is infructuous. Technically, my lord.
Okay. Yeah. This writ appeal is proposed by the appellants, being agreed with the order dated 28/11/2024, passed by the learned single judge and writ petition number 5312/2024, whereby the learned single judge, after hearing the counsel for the parties, has issued a direction to the superintendent of, what is this, GMCH?
Guwahati Medical College.
Guwahati Medical College.
Guwahati Medical College.
Guwahati Medical College Hospital to constitute a board. Where is that? Well, the Guwahati Medical College may at Guwahati, this Guwahati Medical College Hospital at Guwahati, carry out the measurement of height and the eyesight of the respondent, and thereafter submit a report to the respondent through a team of doctors, and thereafter submit a report to this court in a sealed cover through the London Standing Council of Health Department of Assam. Full stop. The respondent has approached the writ court with a grievance that he has wrongly been non-suited by the appellant Airport Authority of India in the process of selection of which post?
My lords, this is Junior Assistant Fire Services.
Junior Assistant
Fire Services.
Please let him speak. We are asking him. In the process-
Junior Assistant Fire Services, my lord, within brackets.
In the process of recruitment on the post of Junior Selection Fire Officer, on the ground that he is falling short of the required measurement of height, and his eyesight is also less than the required criteria. Full stop. And then counsel appearing for the Airport Authority, for the appellant has argued that as a matter of fact, the rules governing the field, as a matter of fact, in the rules governing the field, there is no provision for carrying out further examination of a person participating in the recruitment process, and the direction given by the learned single judge to carry out a verification by a team of doctors of the Guwahati Medical College Hospital regarding regarding the height and the eyesight of the respondent are absolutely illegal. Stop. Learned Counsel has submitted that as many as 85%,
85 including the respondent, my lord.
85 candidates, including the respondent, were declared as unfit on account of not on account of not having the required
Height and eye measurements.
required measurement of height and the eyesight, and in such a case, looking to this fact, it is clear that the respondents have not committed any, that the appellants have not committed any illegality in rejecting the candidature of the respondent. Stop. At this stage, the counsel appearing for the health department has informed this court that the checkup of the respondent as directed by this court by a team of doctors of the Guwahati Medical College Hospital has already been conducted, and you have already submitted the report before the learned single judge.
Lordship, that has not been yet,
And
but it will be provided on
would be furnished before the learned single judge in the sealed cover as directed by the next date of hearing fixed by the learned single judge. Full stop. It is having heard the learned counsel for the parties, and after taking into consideration the facts and circumstances of the case, we are of the view that the direction issued by the learned single judge of carrying out a measurement of height and eyesight of the respondent by the team of doctors of the Guwahati Medical College Hospital are interim in nature, and the appellants are free to raise their grievance before they are free to defend their action of rejecting the candidature of the respondent on all the grounds taken by them, either in the counter to the rejection or the grounds taken in this writ appeal. Stop. Since the learned single judge has not finally disposed of the writ petition and has passed the above referred directions and passed the above referred directions as an interim measure and fixed the next date in the writ petition is 18/12/2024. We are not inclined to interfere in this matter and dispose of this writ petition, this writ appeal at this stage. Ordered.
I am deeply obliged. Deeply obliged.
Ordered.
Pass over matter 26.
But other side is not here, madam.
And other side is not there, but what is in your case?
My case is that, my lord, settlement was issued in favor of the petitioner, my lord. It was subsequently cancelled on the 3 occasions, my lord, which subjected to the writ petition. Thereafter, my lord, by the impugned judgment, my lord, the honorable court at the last page, my lord, para 58 of the judgment, that your lordship will see at page, my lord, page 321, my lord. May I read, my lord? Accordingly, this court therefore directs the respondent state to, more particularly the Commissioner, Secretary, Revenue, Disaster Management Department, Government of Assam, as well as the Deputy Commissioner, Kamrup, to take appropriate step for release of the payment of 45 lakhs to the petitioner within a period of 4 months from the date of the instant judgment. Petitioner is directed to furnish the bank details of the Deputy Commissioner within 7 days from today. It is made clear if within the said period, 4 months, subject to the furnish of the banks, or the said amount directed is not paid to the society, interest at the rate of 7.5% or less shall accrue on the amount of that. My lord, here, my lord, my basic case is that, my lord, 3 bighas of land was allotted to the society, my lord. Society, while undertaking, my lord, that has been cancelled, my lord, which subjected the writ petition. And thereafter, my lord, after cancellation, my lord, lordship kindly have a look, my lord. Though they said that they need a parking lot, my lord, but photographs reveals, my lord, something else, my lord. Page 333, lordship kindly have a look. It has been made as a park, my lord, not parking lot. Just a park, my lord.
So,
They said, my lord, will make a car parking, but they did not make the car parking. They made, my lord, only a kind of park, my lord. And land, if they needed the land, my lord, they could have acquired my land, my lord, because a patta was issued in favor of me.
for what purpose the land was allotted to you?
Page 93 BC in my lord.
Maybe you show, just, yes, for what purpose it was granted?
It was granted page 93, my lord, with, I'm reading, my lord, with reference to a letter directed to, sir, the government of Assam pleased to order settlement of Sarkari land measuring 3 bighas covered by dag number so and so, part so and so under Guwahati Moja in favor of Purvottar Cooperative Society for establishment of modernized factory, etc., subject to the fulfillment of NGO status of the organization and subject to the payment of 30%.
Then what happened?
Then, my lord, again, it has been cancelled, my lord, that your lordship will see.
Okay, fine, then
It was given to me, my lord. I have proceeded for the construction work development.
you have consulted your, this factory or whatever it may be.
My lord, I was about to start, my lord.
The handicraft cooperative society has done modernized factory.
Yes, my lord.
Then what happened?
Then, my lord, again, they have cancelled, my lord.
Okay,
Then after, my lord, they then I have approached the honorable court. Honorable court directed to file a representation in details.
Fine.
We have given details representation that was not considered. And my lord, ultimately, it has been cancelled, my lord. That your lordship will see page 164 and 65.
Then what happened?
Then, my lord, I filed a writ petition, my lord. Then, my lord, honorable,
Why the learned signal, this is the petition?
my lord, my case was not considered in pursuance to my
On what ground the learned single judge has held that there is no illegality in the cancellation of allotment?
Para 53, 318, my lord, it was held by the honorable single judge that in the backdrop of the position of the law as to whether the action of the respondent in passing the impine order was justified. This court cannot be unmindful of the fact that the relief has been sought by the grant of the writ of
No. Please come to panel number 10 of the improved judgment.
lordship. Yes, my lord. Before deliberating on the facts and pleaded the petition, these courts find very significant to take note of the important aspect. The land in question was initially part of the Guwahati jail. It has been existed before the vacating the same. Public interest litigation filed challenging the steps taken for the respondent to allot the land in the various persons organization, the PL was registered 8 of 2001 and division bench of the court expressed that the thereby inter alia directing that the allotment of the in respect of the land where the reserved out jail and including the Guwahati jail included the land in question. The said interim order was sustaining at the load land and settlement of the petitioner. That has PL has attained the finality, my lord, that I have annexed, my lord.
When this stay order was in currency, then only the land was settled in your favor.
My lord, I'll just check it up, my lord.
Check it out. This is what the finding of the landed single judge, what to check out.
Prior to that, my lord, I was being settled. So order to be.
Comment to,
Lordship.
and mind it, the learned single judge in the operative portion has observed that you got this allotment on the basis of fraud and misrepresentation. And still the learned single judge has ordered for this refund of 45 lakhs which you have deposited.
My lord.
If it is a case of fraud and misrepresentation, how you can entitle to for refund?
My lord,
even
there is a judgment of the court.
How you can even entitle for refund also? Now, come with this plea.
Lordship.
Otherwise, we are not in favor of this order, sir.
Lordship will say.
We have played fraud and
Kindly grant me 2-3 days time, my lord. I have to prepare all the cases thoroughly, my lord.
Huh?
I'll prepare the case thoroughly, my lord.
What do you mean by thoroughly? What about this finding?
Finding, my lord, I have gone
You have
through, my lord.
obtained this allotment on the basis of fraud and misrepresentation.
My lord,
Then we propose that why this 45 lakhs which you have deposited in the learned single judge's order for refund be not forfeited.
my lord, lordship,
It's a
give me
case of fraud and
fraud, my lord, in the
misrepresentation,
sense,
and we
my
are not
lord,
going to interfere.
lordship, kindly, lordship, I have given power of attorney to somebody else, but that has not been acted upon. That honorable single judge hold that I committed fraud.
Whatever
Only
it
that
means.
much.
Whatever it means.
But the condition of the
This finding of the, in light of this finding, you have no, that we are not agreeing with the learned single. Complete your instructions. We may pass an order, we are convinced that this 45 lakhs is also not liable to be, are liable to be forfeit.
Also give me 2 days, 3 days time, my lord.
Ask for the date.
Lordship.
For hearing, item 33.
Lordship's pursuant to your lordship's last order, they have passed the penalty order and that has been challenged before the learned tribunal. Perhaps subject to what my senior, the Senate counsel says, there is nothing remains in this writ petition. Perhaps it has become infructuous, my lord. Lordship's order dated 1 August 2024. And appeal that to be. Page 5. Page 5, page 5.
You approach the tribunal for what?
Challenging the impugn order, my lord.
Okay.
Passed pursuant to your lordship's direction, my lord. Page 1, paragraph 5. Page 5. Page 5. Page 5, my lord. The punishment report. 3.10.
Now, what remains? Sir? What remains now?
Nothing remains, my lord.
Okay, learned concept of the parties are agreement that in view of the fact that the that after passing of the due notice by the central administrative body, departmental proceedings were initiated against the respondent. And initiated and concluded against the respondent. And the disciplinary authority by the order dated 8/8/2024 has inflicted punishment of
Page 500, paragraph 3.10.
Has inflicted the penalty, has imposed a penalty of withholding of 50% of the monthly pension otherwise admissible to the CO, otherwise admissible to the respondent Parag
Burman.
for a period of 10 years. The counsel for the respondent has submitted that the said decision of this disciplinary authority has already been challenged by the respondent before the competent appellate authority.
No, my lord, the tribunal,
The
learned tribunal.
Central Administrative Tribunal, Guwahati bench. So in view of the, in view of the above. The counsel for the parties are in agreement that this writ petition has become infectious. This means there is no contest.
Highly appreciated.
Item 24,
May I please, your lordship, lordship, this matter is an appeal from the decision of the learned single judge in the Aizal bench, lordship, dated 31/5/19. Matter relates to lordship rental compensation to be paid by the respondent authorities. Now, if operative portion of the judgment lordship will find at paragraph 21 and 22. Yes. Lordship. If I may take your lordship to page 232. That is how we came into possession of the land. It was initially of 1959, then thereafter another pass was issued in 1960 in supersession of the earlier pass. 232. 232, lordship. Yes, lordship. Yes. Lordship has seen miscellaneous pass 6 of 1960. Yes. If I may read, lordship, in should have been supersession. In supersession of Miss Pass number 8 of 1959, the executive committee of the Mizo District Council is pleased to allot a plot of land measuring 1,000 yards by 300 yards, approximately on both sides of the Chite Lui, north of Old Aizawl, Champai Road, as on the site plan. Copy forwarded to the address of the Chief Executive Member, Mizo District Council under so and so, to the Commandant, 1st Assam Rifle, Aizawl, for rifle range, on the same terms and conditions as laid down in the items of other areas occupied by the Assam Rifles, and also on following conditions. So these are the conditions under which we came into occupation of a plot of land. Now, the case projected by the petitioners before the learned single judge was that on 8/8/1970, a memo was issued whereby it was stated that the lease would be for a period of 10 years. That allotment. Yes, that allotment would be for a period of 10 years. Where is that?
Page 177.
177. Is that? Now, if I may read, lordship, as envisaged under the Mizo District Land Revenue Act 1956, paragraph 5, any passes, example, house site, stall, and others so far issued under this act, coupled with the Lushai District Act 1953, should have been visited with a fixed period. As such, this notification is issued for necessary action. The period of such temporary pass should be limited to 10 years validity, and during this given period, the district council shall not hand over the same to any other person until and unless these passes are converted into land settlement, and the said pass holders will not have any legal ownership, but they may occupy the land for such period of 10 years on the lending system. This order will cover all such passes having no land settlement certificates. However, land settlement will have to have no time bar. Besides this, all the passes for the purpose of garden, paddy fields, farm, etc. issued under Lushai Hills District Grazing Regulation and the Mizo District Agricultural Land Act 1963 should not be covered by this order. All temporary passes as mentioned above, whatever issued earlier, will be regularized accordingly. This order has cancelled the executive so of 1969. Now, lordship has noted that we came into possession of this particular plot of land by virtue of the notification of 1960. Lordship will also see to whom the copies have been served. in page 177. Not to us. We have denied that we have received any such notification in our affidavit.
Which one?
This page 177.
This 8th August. 8th August.
Yes, Lordship, of 1970, which we have denied in our Lordship affidavit in opposition. And thereafter, Lordship, this again subsequently has been modified, and I'll just come to that, Lordship. In 1992, that is Annexure E to the writ petition. I'll just come to that, Lordship. I'll come to that, Lordship.
One.
180.
180.
180.
Yeah.
With reference to the Government of Mizoram Revenue Letter so and so dated 24th May 1990, all land holdings under DPL, passes and mispasses belonging to government department and semi-department, corporation, society or group of persons or person, etc. issued before 25/4/1990 are required to be converted into land lease under the section 11 of the Mizo District Land and Revenue Act 1956 and Rule 14 of the Mizo District so and so 1967, and certificate of land lease will be issued accordingly. Hence, all heads of the departments, semi-departments, corporation, society, etc. are informed to submit the undersigned the particulars of all their land holdings as per the pro forma enclosed herewith during September 1992 to enable the Revenue Department to convert such passes into land leases. The report of land holdings submitted by subordinate officers other than head of departments will be accepted. That is, head of departments are to submit the reports for the department all at the same time in the prescribed pro forma. Failure to submit such returns or pass or permit may entail cancellation of the pass or permit, or such land holdings may be treated as relinquished to the Government of Mizoram. Head of the departments are also hereby requested to submit information reports on the land occupied by the department without formal passes so that necessary action be taken to regularize such holding. Now,
yes.
Now, the whole case of the petitioner before the learned single judge was based upon the notification of 1990 and 1992. What has happened is apparently, since the Assam Rifle authorities were not in the knowledge of the earlier notification, they had not approached the authorities for regularization. That I have to admit before your lordship. But there were cases where
This notification 180 is 1970 or 1992?
this is of 1992, lordship.
This is of 1992.
Yes, lordship.
Yeah.
3rd September 1992, lordship, you'll find at page 181.
Yes.
Now, apparently, the Assam Rifles were of the belief that the land which was given to them by the notification of 1960 belonged to them, and they had started some eviction proceedings also. And the petitioners had gone to the civil court. Subsequently, they have withdrawn the cases from the civil court, and thereafter they have approached the Honorable High Court. Now, in the meantime, lordship, since there were apparently disturbances from the local people, so far as lordship the possession is concerned, there was a joint meeting between the authority of the state and the central government, which your lordship will find at page 233. A meeting was held on 9/11/2009. Hmm. 9/11/2009. And if I may take your lordship to page 235, the relevant portion, paragraph 4. Hmm. This is JSP2, that is Joint Secretary Police, observed that since the state government had issued land passes to Assam Rifles and later on inadvertently allotted a portion of the said land to some other private parties, they have to take corrective steps in the matter.
Who is this JSP?
That is an authority of the state, Mizoram. Joint Secretary, Government of Mizoram, Nikhil Kumar Wal. That your lordship will find it 233.
Yes.
And these are the decisions, lordship. The state government will take corrective steps to ensure that there is no overlap between the land passes issued to the Assam Rifles and the LAC issued to private parties subsequently. Now here what has happened, lordship, though a notification was issued in 1992, it appears that petitioners were issued the land passes prior to that. It was the land passes were issued prior to that. Two, being an armed force of the Union in case of Assam Rifles, in case Assam Rifles has not got converted the land pass into a land acquisition certificate, the state government may issue necessary LAC to Assam Rifles. As the land allotted to Assam Rifles has been encroached upon by some encroachers, issue of payment of rental charges does not arise. State government may clarify the same to these encroachers. State government may resolve the issue of payment of rental charges with the private parties and close the case. Now thereafter, lordship, we have been approaching the revenue authority, which your lordship will find at page 236, 237, and 238.
Yeah.
But this has yielded no response as on date.
Yes.
Now, the learned single judge, if I may read paragraph 21 of the judgment. From the above abstract of verification report, this verification report, lordship, though a statement had been made that it was a joint verification report, it does not contain our signature. We have not signed it since we did not accept it. 21, lordship, if I may read. From the abstract of the verification report, it can be seen that the petitioners have been issued their respective passes by the revenue authorities. And the Assam Rifles, on the other hand, claimed that rights over the lands on the strength of MISPA 6 of 1960, as already noticed earlier, in view of notification issued by the Erstwhile District Council on 8/8/70, the communication dated 24/5/1990 and the notification dated 3/9/1992, the MISPAS number 6 of 1960 ought to have been converted into land lease as was instructed to all MISPAS holders. However, the same was not done, and therefore, having regard to the same, the subsequent follow-ups made by the state government on 3/10/2007, 29/9/2009, 2011, 2011, 27 so and so, I am of the considered opinion that the petitioners cannot be deprived of the rental compensation for forcible occupation of their lands with effect from 1972 to 2006. As per the assessment made by the state authorities in so far as non-substitution, this is won't be so material. In the result, considering the case in its entirety, petitioners are found to be entitled to rental compensation amounting to 21.72 crores for the period from 1972 to 31/12/2006. Our case before the learned single judge was, Lordship, the notification of 1970 was not brought to our knowledge. There was neither any paper publication to that effect, which was brought on record. And we are still in possession. When we are in possession, how could you have issued land settlement certificates to others? Now, if at all this has to be believed, that means the land settlement certificates are only pieces of paper. They do not have any possession over the land because we are in possession of the land. And we say, make a demarcation. We approach the revenue authority. Revenue authority is not a party in the writ petition. Revenue authority is not a party in the writ petition. And even the state government, when it had filed its reply, the state government says that, I'll take your lordship to that. What the state government has said. At page 262. If I may read paragraph 4. That it may also be submitted here that the annexures of the writ petition were initially examined and it was found that the boundary descriptions of the land passes of the petitioners were not included. Thereafter, the relevant records pertaining to the lands of the petitioners were sought from the Office of the Director, Land Revenue and Settlement Department, who was not arrayed as a party in the instant writ petition. After examining the relevant records pertaining land passes of the petitioners in the writ petition, some of the passes in the official records were found to be different from the passes annexed by the petitioners in the writ petition. It is their stand. For instance, land passes so and so of petitioner number 5 can be seen to be 4.52 bighas in the official records, whereas the land pass annexed to the writ petition, the area is 12.80 bighas. So there was a discrepancy so far as the land holdings are concerned. And my submission before your lordship is, if we are in possession, all right, you have not cancelled my notification of 60. I am still in possession. Have you asked me to hand over the land to the government of Mizoram? Because once my right over the land goes, it will vest with the government. It will first vest with the government. Only thereafter, you may issue a land settlement certificate in favor of the private respondents. Here is a case before 1992, the land settlement certificates were issued to the private respondents. And the matter so far as demarcation and the settlement certificate that has to be issued to us is before the revenue authority. They are not doing anything over the matter, lordship. Then this case comes up. Revenue is not a party. Therefore, lordship, until and unless there is a specific stand taken by the state of Mizoram, which would say, no, your request cannot be adhered to. If it by request for issuance of a land settlement certificate in my favor is not accepted, land goes to the government. Land goes to the government. Thereafter, you do whatever you have to do. But right now I am in possession. There may, I would fairly submit, Lordship, there may be a case where I have maybe encroached upon somebody or somebody else has encroached upon me. But that has to be demarcated and that is before the authority and they're not doing it.
Yes.
That is precisely my, therefore, Lordship,
Lordship, I'm waiting for some of the landowners, some of them have passed away in the meantime. Those who are alive have filed their Wakalat numbers. So what has happened?
This case case is same.
Case is identical, Your Lordship. So what has happened, Your Lordship, is that initially Your Lordship is aware Mizoram was a part of the state of Assam. It was called the Lushai Hills district. At that point, there was a district council in that area under the 6th schedule. So the land settlement process in the district of Mizoram was under the Act of 1956. So under that act, the then Mizo District Council issued a miscellaneous pass to the Assam Rifles, one in 1959, which was superseded in 1960. That was ostensibly for the purpose of setting up a firing range. Now, the act itself says that such miscellaneous passes, because they do not confer a heritable right, only a right of usage, they have to be for a fixed period. But the pass which was issued to the Assam Rifles, Your Lordship will see, may have noticed, that there is no period specified in the pass. But the act mandated that it had to be for a fixed period.
What period?
Yes.
Period, what?
Yes,
what
since
fixed period up to 6 months.
yes, there has to be some period specified in the
Where
pass.
is that?
There was nothing in that, nothing in the past. The act, I have the
So Act says it should be for a fixed period. And if the pass doesn't specify that period,
yes,
then up to what?
Yes.
We can assume that this pass was in currency up to what time?
To correct this mistake, Your Lordship, the notification of 1970 was issued, 8 August 1970, where it said that all passes would be valid for a period of 10 years.
Okay.
Now, pursuant to that notification of 1970, after Mizoram became a union territory in the year 1972, Your Lordship, it became a union.
70, this notification 70 is at page?
It is at page number 177, Your Lordship.
177.
Yes, Your Lordship.
Yes.
Yes. It says, as envisaged under the so-and-so Act of 1956, para 5, any passes, example, so-and-so, so far issued under this Act, coupled with the Lushai District Act of 1953, should have been vested with a fixed period. As such, this notification is issued for necessary action. The period of such temporary passes should be limited to 10 years validity, and during this given period, the District Council shall not hand over the same to any other persons. Until and unless these passes are converted into land settlement, the said pass holders will not have any legal ownership, but they may occupy the land for such period of 10 years on lending system. The order will cover all such passes having no land settlement certificates. However, land settlement will have no time bar. Besides this, all the passes for the purpose of garden
Settlement will have no time bar.
That means this is a pass. Land settlement would refer to pattas, for example, Your Lordship. Those would not have any time bar. Land settlements, apart from the passes.
This speaks about some temporary passes.
Temporary passes.
So where is the temporary pass?
The temporary passes, both the passes, Your Lordship will find the first one of 1959 at page number 175A. This is the original pass. 175A.
When it mentioned in this, it is a temporary pass.
It says it's a miscellaneous pass number 8 of 1959, Your Lordship.
Temporary pass, what mean by temporary pass in the claim?
Your Lordship, if I may just hand over the Act, Your Lordship. The Act contains provision for issuance of passes for usage of land for a specific purpose, for a fixed period.
Regarding this 59 pass.
Yes.
And the 60 pass.
Yes.
There is no mention that these are the temporary pass and are for a fixed period.
The word, yes, precisely, because the term was not fixed under the pass, Your Lordship. That is why the correction had to be issued later.
Which correction?
The correction of 1970, your lordship.
1970?
Yes.
Okay. It says temporary pass.
Yes.
So
Now,
what about this temporary pass? From where we, this category of temporary pass, where it is mentioned?
the word temporary is not there, your lordship, but the miscellaneous pass itself means a temporary pass, your lordship.
You just satisfy on this.
Yes, your lordship.
Miscellaneous pass means temporary pass.
Yes, your lordship. Because
That, you just.
Lordship.
show us.
Yes. Lordship, for this, if I may take your lordship to the lordship. One. Lord. Applied on a parcel. To address your lordship's query, the Act of 1956, your lordship, contains provisions for issuance of only one kind of pass. So there is no difference between there is no permanent pass. There is only passes which can be issued, and passes by their very nature, as described in the Act, are temporary because they are supposed to be for a fixed period. Lordship.
Satisfy us.
Lordship.
Admittedly, the pass was issued to them or the miscellaneous pass or what, under what category, though there is no category of miscellaneous pass.
Yes, there is no category.
They were issued in pass in the year 1960.
1960.
Then order 1972 came.
1970.
70 says all temporary passes
All temporary passes.
could be only for the 10 years.
10 years.
Admittedly, it was not a temporary pass because no time tenure was fixed.
No tenure was fixed.
No fixed.
No fixed.
Then in the year 1992, another notification was issued, which says this, page number 180.
180.
With reference to the government of Mizoram, so and so, so and so, so and so. All DAPL passes and miscellaneous passes. For the first time, this speaks about miscellaneous passes.
Yes,
Okay?
lordship.
And they said, okay, you apply for the 5-year return and then only the land certificates will be issued to them.
Lordship.
Which says failure to submit such return or pass on permit may entail cancellation of pass on permit of such holdings and or such holdings may be treated as relinquished to the government of Mizoram. So admittedly they have not filed any return. That is the cancellation order.
But your lordship, the land settlement certificates were issued to us, your lordship. They were issued prior to
Land settlement certificates were issued to you
this notification.
over the land which was already in occupation of the Assam Rifles.
Yes, your lordship.
How?
No, what I'm saying is, your lordship,
That the land was not barren land or not under the, it was not like that, it was not occupied by any person
it was barren
or
land.
any other.
It was, they were not using it, your lordship.
So it was, there is no question of use, it was a shooting range.
What
What to do you?
what I'm submitting, they were perhaps not, I'm subject to what my learned friends, not even using it as a shooting range.
That's altogether different thing.
Yes, what I'm saying, your lordship,
Whatever
is,
it may be, they were in authority on the basis of a pass which was never cancelled.
yes, no, what I'm saying, your lordship, is, since the validity of the pass itself, as per the notification 1970, was supposed to be for 10 years. Upon the expiry of the
What
10-year,
temporary passes?
because your lordship will kindly see, the act does not contain provisions for any other kind of passes, your lordship.
That.
There is no difference between a temporary or a permanent pass.
What do you mean by temporary pass?
The word,
Temporary pass means temporarily for a particular period.
yes, your lordship.
So here no such period is defined.
Precisely, your lordship, because the act does not contain provisions for, does not distinguish between two different kinds of passes, permanent or temporary. There is only one kind of pass which can be for a fixed period. Now, since the passes issued to the Assam Rifles were since the passes issued to the Assam Rifles did not contain any such period.
That's why only the petitioners have chosen the right course to file a civil suit. So on the basis of the evidence of the parties adjudicating the dispute, the civil court could have passed a decree. That suit you have withdrawn.
Lordship, that happened a long time.
Whatever it may be, not you, particularly not you advocate, but the petitioner.
Yes, but lordship,
It should have insisted on that civil suit may, if they could have gone, evidence, have been, evidence led by the parties that what kind of land, who is the actual owner of the land, what is the nature of your passage. Everything is
perhaps that suit, your lordship, perhaps we may not need to subject to.
purely disputed questions of fact, which can't be decided on the basis of affidavits in the writ petition, sir.
I understand what is falling from your lordship.
Another very important aspect is that in the year 1990, somewhere in 1992,
Lordship.
there is this joint meeting,
Joint meeting was in 2010, your lordship.
2010, where one of the joint secretary of the state government opined that these passes are wrongly being issued in your favor. And therefore, the government should correct this mistake.
This.
And immediately.
No, that is not the opinion of the state government, your lordship. That is, if I may just take your lordship.
Secretary, the state government.
No, the joint secretary, what has been recorded in the minutes is what the Assam Rifles has stated. If I may take your lordship to the meeting again, because after that, there was a joint verification exercise also conducted. 190.
So it is neither here nor there, you mean to say that these minutes of meeting.
These minutes of the meeting, your lordship, because that's what the Assam Rifles has said, that this is wrongly issued. The government of Mizoram has admitted that the land, your lordship, belongs to the petitioners, the respondents here.
Where is that?
Yes, your lordship may come to page number 196, your lordship.
196.
196, your lordship, of the paper book, page number 196.
What is this 196?
This is the verification report where there was a verification conducted by the government of Mizoram.
Sir, and the verification committee has come to the conclusion that they are entitled for rental charges also.
Lordship may
What
kindly.
is the authority of that committee?
Because your lordship, under the.
It was only for the purpose of verification.
Because under the Mizo Accord, your lordship, paragraph 13B of the Mizo Accord, there was a provision that for illegal occupation of land belonging to private citizens by the armed forces would be bound to pay rental compensation upon joint verification. It was under the authority from the Mizo Accord is on record, your lordship.
So is there joint verification report?
It is at 196, your lordship.
Yeah.
If I may read it out.
Where is the signatures of the Assam authority?
This is the report prepared by the revenue authorities.
Joint verification report by whom?
The report is, this is a communication of the findings of the report by the revenue, by the
Where is that copy of the report? Where is this, Assam authority has also signed that?
Assam Rifles, their signature is not on this report.
So how did that report is, conclusive?
But the report
But the joint verification report is there, that all the persons who have jointly verified.
Lordship,
should have-
this report is not under challenge by them, your Lordship. They have not challenged the report before any court of law. What this report specifically, this report, if your Lordship goes through, it will be, I mean, this is the foundation of my case in a way, because this report, I'll just read out the relevant portions, because the Assam Rifle has not stated that they were not present in that report during that spot verification. They were there. They have not challenged it before any court of law. Lordship may kindly go through the report. What it says, I'll just read out the report, your Lordship, because the entire history of the dispute can be made out from it. At page number 196, two officers of the Assam Rifles are present. The landowners are also present. On spot verification, it is found that the Assam Rifles have been occupying a certain plot of land on both sides of the Chite River for firing range since long back till today, whereas the same plot of land is covered by private land holdings. On scrutiny, it is learned that the Assam Rifles were once allowed to do firing practice in the area by miscellaneous pass number 6 of 1960 conditionally without vesting it with ownership title over the land. According to the rules and regulations in the revenue manual, there is no relevant provision to base upon for issuing such kind of miscellaneous stroke DPL passes. Therefore, Government of Mizoram Revenue Department had eventually issued notification number dated 3rd September 1992, in which all the miscellaneous stroke DPL passes issued before 24/5/1990 are required to be converted into land settlement.
Yes.
Are required to be converted into land lease under Section 11 of the Mizo District Land and Revenue Act 1956 and Rule 14 of the Mizo District Land and Revenue Rules 1967. Failure to submit the return reports of such passes or permits for conversion into land leases during September 1992 may entail cancellation of the passes for permits. The Assam Rifles failed to submit the required return stroke reports within the stipulated time for conversion into land lease. In this connection, the representatives of the Assam Rifles have stated they are occupying the land only on the ground that they have not received cancellation order of miscellaneous pass number 6 of 1960 from the Revenue Department, and further stated that the site will be utilized until and unless the headquarters is shifted to so and so. It is learned from the claimants that in the year 1972, just after the inception of the Union Territory of Mizoram, the Government of Mizoram Ministry of Revenue, headed by so and so, had a decision to allow the whole area on both sides of.
So where is that decision? It is learned from the claimants.
Yes.
The claimants have said, and it was a gospel truth. And what is the authority of the verification committee to give all these findings?
Because they are the
This is not the adjudicating authority, sir.
No, Lordship, they are the custodian of the revenue records, Your Lordship. Unless the Assam Rifles.
On scrutiny of the all connected papers of checking land records, general register, draft file, revenue department has seen checking performed, it is found that all the revenue buses in district of Beru found to be genuine. And they have been paying monthly mandatory revenue tax so and so state. However, the private landowners are not able to develop and look after the land, continuous forcible possession of so and so, so and so. It is also some of the converted number of houses. But to avoid complication and to reduce the list of claimants, they are claiming rental charges as per their superseded previous pattas as per different clause, further so and so recently not been affected. However, in some of the cases, transfer of ownership, rental charges will be shared by the persons according everything it has decided like a judge. What's this authority?
This is the Deputy Director of Survey.
They're all disputed questions of fact. It can't be good.
But unless a dispute is raised, Your Lordship, they have not challenged this report. The Assam Rifles first.
The learned single judges place reliance on these. So we have to go through this report itself. Whether this reliance on this report,
Lordship.
on the basis of placing reliance on this report, any decision can be passed on that.
Lordship, another aspect would be even if this report is not there, pursuant to this report, what has been the conduct of the Assam Rifles? Because till 2010, there was no.
In fact, the problem is this, if we record this finding, that whatever the settlement in your favor was not in accordance with law, it was illegal, since the land was already in occupation of the Assam Rifles on whatever basis, on the basis of miscellaneous password, and that has never been cancelled, how that land can be settled in your favor?
No, Lordship, what I'm saying, land was not in their possession. They have in fact issued eviction notices to us. Those are on record, your Lordship. They never used the land. The passes were issued to them.
So whatever it may be.
After
that
the cert-
land, some pass was issued in their favor.
Look.
Allotment of the land,
It was.
if that allotment is not cancelled, how the land can be allotted to you people?
Because you.
Plain and simple, it's a.
I understand.
common
What is-
sense. It's a matter of common sense. One land was allotted to you and you have not used that land for any other purpose. Then certainly that without cancellation of your allotment, that land cannot be allotted to Mr. Chaudhary.
But if the,
But this is plain common sense.
but this notification of 1970,
So 1917 notification simply says, where is the cancellation even though, yes.
Because 1970
there is
does-
the order of cancellation or order of eviction. Just since this was only for the 10 years, you vacate this land, where is that?
because the 1970 notification specifically says, it starts with a non-obstant clause that until and unless this
This
passes
1970 notification is dated
8 August 1970
and the land settlement passes were issued in your favor.
in 1972,
1972, after that.
after that.
Recording this that the land has already been cancelled in their name and
No,
therefore now it
that is not
free for
record. The settlement certificates are in the official format. It does not have any.
material before the land settlement offer to log this land.
But perhaps those issues the Assam Rifles are not raising, your lordship. What they have, after the 1970 notification was issued, your lordship, the validity of all passes remains for 10 years. I'm just placing this for your lordship's consideration. So it says that until and unless those passes are converted into land settlement certificates, upon expiry of that period of 10 years, the passes shall be cancelled. The act says that there is only one kind of pass. There is no miscellaneous temporary permanent pass. There is only passes which can be for a fixed period. Now, the 1970 notification makes that fixed period as 10 years because the original passes did not have.
When it was already there,
Lordship.
there was the need of this 1992, 2010 notification.
The
It was already clarified.
The
that
ni-
10 years, not more than 10 years.
Lordship.
Then there is the.
Because
there
Mizoram,
is
your
the
lordship,
need for issuance of this.
Because
2010 notification.
in the state of Mizoram, your lordship, this is not the sole dispute, your lordship, because of the history of the
No,
state.
sorry, 1992 notification.
1992.
What is the need of that?
The 1992 notification was issued, your lordship.
Already clarified it,
Lordship.
that whatever kind of passes, this period of passes would be only of 10 years.
Lordship.
Until and unless it has to be regularized or whatever it may be, the procedure which they have given.
Lordship.
So then there was the need of issuance of this 92 notification.
This 92 notification, my understanding of the reason behind issuance of this notification is, lordship, because this is not the only dispute in the state. In the state of Mizoram, okay, instances of occupation of private land by armed forces was a problem, your lordship, because that is a problem. That is why it had to be specifically addressed in the Mizo Accord, the tripartite settlement. Now, because to address those issues, your lordship, perhaps in the year 1992, after the state was constituted, the government of Mizoram issued Am I not mulu hoat na?
And how this compensation was determined to the tune of rupees 21 crore?
Because after the verification report from the documents which are available in the record, your lordship, for the first time in the communication of 15th of November 2010, at page number 201, the government of Mizoram has quantified that amount. It's at page number 201. After the verification exercise of 23/2010, the amount was quantified on 15th of November 2010. Your lordship. And that additional papers.
And here the government, this whatever it may be, but the Mizoram government stand is that this whatever the issuance of land passes in your favor, that is not in accordance with law.
No, their stand, perhaps your lordship, is not born from their records, your lordship. They stand on affidavit. Because lordship will kindly see that there was not a one communication. There has been a series of communications which they have addressed to the Assam Rifles. If it was one communication, then perhaps it would have been a different matter. Series of communication across the years, your lordship.
This 21 crore,
Yes, your lordship.
that is in this department's letter
Lordship.
2007, 2009 and 2008.
Lordship.
And this joint verification carried out
2010.
उससे पहले compensation ascertain कर लिया.
That the-
Then okay. The joint verification was carried out in the year 2010 and the joint verification and the compensation was determined in the year 2007 and 10.
Because perhaps what has happened is, that the government of Mizoram will be able to respond, but my understanding would be,
What they will explain, yes, ma'am.
no, perhaps.
Ma'am, explain it.
Yes, Lordship.
How you determine this compensation before the joint verification?
Yes.
What
But-
years?
That was done in the year 2010, Lordship, and the assessment was done in the year 2007.
So that's why only you have to explain how this mechanism, please, let us understand how you are verifying all this without this as determining the compensation before verification. So we may apply to all over India also. This is a mechanism with the state of Mizoram is having, and this is a very good mechanism. That before verification, they are so capable of determining the compensation before verification. That's good.
In fact, Lordship, everything is clause with Lordship, because without cancelling the past, automatically the hitting the it is cancel automatically, passes was issued, and in fact our affidavit was filed. Lordship, I have seen the affidavit that those passes are not genuine. Lordship. First affidavit we have stated, Lordship. Then the other communication, Lordship, we have stated that those are genuine. So everything, both sides are there. Lordship.
Not both sides. This is the only confusion created by the state of Mizoram.
I understand.
And heavy cost should be imposed upon you.
Regarding that
In
assessment.
what manner you are dealing with this acquisition matters? Suppose if a land of a person is occupied illegally, certainly he or she is entitled for compensation, but you are dealing in such a manner and changing his stand from time to time.
Regarding that, how the.
One time you are saying this Assam Rifle will pay the compensation. Before this court, you say, no, they are not entitled. What is this?
Regarding how the compensation was assessed, Lordship, I have verified the record. Lordship,
What
already.
verification? Do you really be able to verify this?
Right, Lordship.
You be in position to verify this. That the joint verification was conducted in the year 2010 But we have determined the compensation in 2007 itself. Whether you will be able to justify this or explain this.
Let me try, Lordship, what,
How can you try even?
under
How
what
can you
circumstances,
justify it?
under what circumstances they have assessed the compensation and how they have assessed the compensation?
Ms. Bhattacharya, where is that statement in your affidavit that the settlements are not genuine? You said in your first affidavit.
That affidavit is not annexed, but in paragraph 14 of the judgment.
Yeah.
The ownership of the land of the petitioner is doubtful. That was the first affidavit filed by the state.
And the second affidavit says,
If second affidavit, they have annexed the, they have annexed the.
There is one curious aspect, Your Lordship. In the same affidavit where they have said ownership is doubtful, they have also gone on to say, however, the respondents do not deny the communication stated 15/11/2010, 2012/2011, 27/9/2012, and 22/2013. So they have also not denied those communications.
Page 262.
communication of what?
These Lordship will kindly have paragraph number 14.
The respondent number 3 and 4 also denied a joint verification exercise by the enactment that when we have made value so and so does not bear the signature of the Assam. There cannot be. Therefore, this cannot be a joint verification report. Then
No, what I'm saying is that paragraph number 14.
14.
Yes, 14, where they have stated that some of the land settlement certificates are doubtful. Then they've gone on to say in the same paragraph that the
Para 14 of the judgment or the.
paragraph number 16, Your Lordship, paragraph number 16, 16, I beg your pardon.
Again on 17 to the affidavit stating that
Yes.
11 reports pertaining to the directed and passes the affidavit found to be different from the past. The area of the land as per the past for intact. However, did not deny the communication 15/11. What are these communications?
These are the communications addressed to the government of India demanding that amount of 21 crores for disbursement amongst the
To whom?
petitioners, the land settlement holders in that area.
These letters contain your name?
The letters do not, one of the letters contains our name, Your Lordship.
Page 207. Lord.
Yes.
Was also reiterated director of land revenue.
That letter contains. Oh.
207.
Yes, those 208, that letter contains our names, Your Lord.
The letter issued by the Assistant Secretary of the Government of Mizoram Revenue Department, the Joint Secretary Government of India.
And this is not some director writing, Your Lordship, right at the secretary level. So
Second paragraph, Lordship, further putting you all the connected papers and land records files of the Revenue Department, it has been confirmed that all the revenue parcels in respect of the private landowners are genuine for which mandatory revenue taxes are being paid by them as per the state laws, landlords.
and the next communication at 208, that contains our names, Your Lordship, just so that. So otherwise, our land settlement certificates and our pattas, they have not been denied by the state of Mizoram. In fact, the Assam Rifles, if anybody should go to the civil court.
They are also not doubting your patterns. Question here. When the land was occupied by some person and or by the Assam Rifles and that was not cancelled at any point of time. Under what circumstances the pattas can be issued to you?
My reply would be that because the period was for 10 years and the 10 years had elapsed.
That's why only initially we observed that we have rightly approached the civil court. So it can be looked into by the civil court, taking into consideration the evidence produced by the parties, and then it can come to any conclusion. On the basis of these affidavits, you frankly speaking, Mr. Bhattacharya, you are convinced that, yes, you have a full proof case of this compensation.
Not a foolproof case, but a strong case.
Yes, how can we do that?
But perhaps if somebody needs to go to the civil court, I mean, just for your lordship, because the government of Mizoram, according to them, their consistent stand has been that
There is no stand, in fact, no consistent stand. Where is the stand on that?
perhaps if Assam
Even
Rifles,
we believe that today what the madam is arguing, tomorrow she'll argue something else. She may say, "Okay, yes, sir, they are entitled for this compensation, no, they are capable of doing it. The state of Mizoram is having a kind of, yes, they can do it.
then may I make one prayer if your lordship may have it day after tomorrow. I'll seek instructions from my client whether they want to approach the civil court.
That could be,
Because if a finding is rendered by a lordship on it, either way, your lordship,
we
perhaps
have to record some finding. We are not saying that prima facie we are of the opinion that this judgment requires some review.
I'll just seek instructions on that aspect, your lordship, whether it very willing. Deeply obliged.
Item 35.
My lordship, please. Lordship, the issue pertains to the this implemented order as by the honorable single judge. We have challenged the order of the Board of Revenue and the order of the additional deputy commissioner in respect of a cancellation of mutation. Now, just I'm laying the facts, my lord, before I enter into the point of law. My lord, we the appellant herein, the appellant number 1 and 2, we are the owner of the land of 2 vigor, 3 kata, 4 lucha by UFA purchase upon a consideration amount. Lordship will find at page 51 and page 60, the 2 sale deeds are there in our favor.
You purchased the land from Munawar Ali.
Manohar Ali, my lord. He is the husband of respondent number 3 who has challenged the entire mutation order, etc.
Munawar Ali.
My lord.
How Munawar Ali was in how he,
As per the revenue records, in the, on 13/8/2003, his name was mutated from the legal. On the basis of his statement is on the basis of the oral gift.
where is that oral gift?
There is oral gift.
Whether that oral gift was proved.
No, because this is a revenue proceeding. So therefore, there would be no question of the adducing evidence, etc. Now, without challenging what, now our contention is, my lord, our contention is the legal issue is.
Rights and revenue court can very well record the evidence.
Regulation 41 of the Assam Land Revenue Regulation says that if you are not in a position, but you claim to the right to do so, then the revenue authority shall refer to the proper court. That is Regulation 41.
So, before when the mutation proceedings were challenged
By the respondent number 3.
by the respondent number 3.
Correct,
that, the mutation only in favor of Munawar Ali was.
And also in our name.
Oh, that's.
Yes,
subsequent.
yes,
So
subsequent.
about the mutation.
Of my vendor's
in
name.
Munawar Ali was under challenge.
Yes, my lord.
Then the consequential mutation.
That
in
was,
your favor, that
yes,
was also,
correct, ma'am.
challenged.
Correct.
That's very.
My mutation, my,
Doubtful that how this revenue authority on the basis of simply that there was a oral. And therefore, oral transfer or oral will or whatever.
our land revenue regulation says that if the recorded pattadar, without taking any evidence, if they sign on the revenue records in respect of their no objection for transfer of the land, then the land may be mutated in the name of the person concerned. As per our regulation.
Where is
Now the basic.
Where is the order passed by the authority who has cancelled the mutation?
Additional. Page 84.
84.
Yes.
Yes. They were the sisters of Munawar Ali.
Yes.
They were the sisters of Munawar Ali.
Now, Manohar, the land originally stood in the name of the Abdul Ghani. Now he has 2 sons. Now the legal heirs of the
Other son.
other 2 sons, they transferred the land in favor of Manohar Ali, husband of the respondent number 3, by UFL oral gate. That is the contention of the Manohar Ali. Then thereafter the sale deed were executed.
Then who challenged that mutation entry?
The respondent number 3, one of the legal heir of the original owner.
Original owner.
One of the legal heir.
One of the legal heir means she was daughter, son.
Daughters.
Daughter of the original landowner.
Yes,
means
correct.
Sister of the Munawar Ali.
No, wife of the Manohar. Why Manohar Ali, son-in-law of the original owner.
Munawar Ali.
He is the son-in-law of the original owner.
And the land was mutated in the name of son.
At the consent of all the legal heirs, except respondent number 3 in favor of Manohar Ali.
So the consent of the respondent number 3 was required.
Absolutely required.
So
There
was no consent of the respondent.
I'll come to that point. That she has only 1 share. Others are not challenging. She has only 1 share of that. Now the sale deed was executed.
Whether that share of this whatever the legal heirs of the original landholder was determined.
Lordship, I'm
by
very.
petition decree or what something.
I'm very fair to this aspect that there appears to be some illegality. There appears to be some illegality by obtaining without the consent, the share to be determined, everything is there. But rightly or wrongly, two sale deeds were executed in due process of law by obtaining permission. Now, may I
The
just,
vendor who has executed the sale deed.
who has no title, how can he pass a stroke? That's,
Plain and simple formula.
that is an issue, my lord. But the question is that after execution of the two sale deeds, thereafter, also some sale deeds were executed during the course of the passage of time. Now, admittedly, I am in possession.
Best course for you to ascertain your right, file a suit.
No, no,
Title suit, file a title suit.
that's
Ultimately,
that's
the
my
mutation
contention.
Proceedings are only fiscal proceedings.
No, that's my contention, my lord. That's my contention.
Yeah.
Now, after the sale and purchase of the suit land, I am in possession of the land, there is no dispute.
Yes.
Now, if I am in possession and somebody has a right to claim to have a possession, then regulation 41 says that revenue authority hands are tied. They cannot do anything except to refer the person concerned to the civil court. Who alleged to be the claiming the question of the claiming the possessions. Now, the declaration that has to be sought by the respondent number 3 for cancellation of our sale deed.
Respondent number 3 is admittedly one of the legal heir. Why should she seek this declaration? You seek a declaration. Whatever the oral gift or whatever it may be, that was in accordance with law, that was accepted. Seek a title degree from the civil court.
My lord may appreciate one thing. My lord appreciate. Supposedly, in a civil suit, lordship is have a experience, and we all that the sale deed in various suits are put in challenge on various grounds. Now, unless that instrument is cancelled, a registered instrument and cancelled, the title cannot be whipped out, and the revenue code has no jurisdiction to do so.
Check the law, sir.
I'm referring to 41.
Original order itself is void ab initio. The subsequent registration and all will go. There is the Supreme Court judgment, specific Supreme Court judgment.
My only submission is that the revenue authority cannot because cause of action arose not in my favor. Cause of action arose in favor of the respondent number 3. At regulation 41 is very clear, my lord, that if somebody claims to be in possession, but he is not in possession, then the revenue authority refer him to the proper court, that is the civil court. And a division bench judgment of our High Court also reiterated the same thing, that regulation 41 has to be followed.
Claiming whatever the possession and all, she simply challenged the mutation entity in your favor on the ground that it was
Correct.
this.
The question is, my lord.
In the name of one person.
Correct, my lord.
Who sold the land to you.
Correct.
Not correct.
Now, my respectful submission before the court is that my possession on the basis of the title deed.
There is the question of possession. There is no order of dispossessing you from the land. They have simply cancelled the mutation entry. That's all.
That they cannot do.
Why can't do?
Yes, that is regulation 41 prohibits them.
What says, read 41?
My lord.
Is there any law which says that the mutation entry can't be cancelled?
No, then if it is a disputed question of fact, then of the title, then it has to be go to the civil court.
Nothing. There is no question of disputed title, question of title and all. It's a plain and simple case that I am also.
Then the revenue code having a power to cancel the sale deed, my lord.
No. I am also, there is no prayer for cancellation of the sale deed. They have simply said, okay, this man died. He is having so and so legal
I
representation.
understand, my lord.
And out of these, the legal
Yes,
representatives,
yes.
land was recorded only in the name of one person. That's all. This was the plain and simple.
I understand, my lord, but the problem lies in that my mutation, not only basis of my possession only, but on the basis of my sale deeds. Once the mutation has been cancelled, that virtually cancel my
Who
sale deed.
executed those sale deeds?
As per the revenue records, he is the owner.
So that's why only they have challenged, sir. He is not the only owner. We are also entitled. Our name also was also to be entered in the mutation entry. But illegally, it was not entered.
My only limited submission is, my lord, that the revenue court as well as the honorable single judge ought to refer the parties to a civil court for determination of the question of the title and the possession. The revenue court having no
There
power.
is no question of referring the matter by the revenue court. If you are agreeing, then you are seeking title for the land, you approach the revenue court or civil court, whatever it is.
No, I am not seeking title. My title is already there by a bona fide purchaser by two sale deeds.
Now the mutation itself has gone now. Where is your title?
Therefore, the question lies, my lord.
Nothing.
The lordship kindly have a look at regulation 41. And also a division bench judgment of this honorable court. That whether the revenue authority having a right when the possession is not there to cancel the mutation.
Oh,
Yes.
they can't do that.
No,
This is the judgment.
no, that this is the provision of the law.
This is the judgment of this court.
Now, this is
That
the
is the
provision also referring.
If a person is not in possession, he
Yes.
cannot challenge the mutation.
Yes, Your Honor.
This is the judgment
Yes. No, this is the provision of the law, my lord.
of the law.
The last part of the judgment. This is my very short judgment. Because to my understanding, my lord. Yes. Yeah. Right. Okay, welcome.
Regulation.
Regulation 41.
What is it?
This is a same single bench judgment, another judgment, is a paragraph 5.
How is it relevant at all?
My lord.
It's relevant at all.
Kindly bear with me, my lord. Article 4, regulation 41, lordship kindly have a look. If somebody.
Give us the regulation 41, first of all, we'll see to it.
Yes. Please.
Council, this absolutely.
41. 41. Okay. 41.
You give your copy.
Oh, yes. Only to see, my lord, that if person is not possession, then refer to the civil court. Kindly see. From end. The only question, my lord, I will not go into the facts.
Why you are not gone to the fence with the case for listed for hearing?
No, what is my point?
Listed for hearing and you have said
No,
you
no.
have not gone through the facts.
No, that's subject to correction, my lord. I'm already said before this on court that by two sale deeds, these appellants purchased the portion of the land in question from one Mr. Manohar Lal. And accordingly, the mutation was granted in 2003 in the name of Manohar and in 2004 in our name. Now in 2006, the revenue appeal was filed. In the revenue appeal itself, the respondent number 3 said that the Manohar Ali has no right to, has no sellable right. Exactly the word has been said. And thereby, she also questioning the title of Manohar. Now, thereafter, the Board of Revenue also entered into the title. And saying that
There is no question of title. They have simply said that once the how the Manohar Ali was the sole heir of the deceased and how all the name was mutated in his favor. That is not correct
No,
because the other legal representatives are also there.
as per the revenue records, my lord, as per the ADC order also, that out of the 6 patadar, 8 they were signed in the Chita. And
Before the Board of Revenue, they also said that we have never.
that is whether that affidavit is correct or not, I am not on that, because we have challenged that affidavit also.
That cannot be.
That affidavit without being proved, that cannot be taken into consideration because of the fact that they admitted that they have.
This is purely factual aspect and concurrent finding of the 3 courts. Well,
Therefore,
recommended jurisdiction, the court is not supposed to.
therefore, only to answer a point of law, my lord, we are before this honorable court that the regulation 41, as your lordship has also gone through, the last part, which is segregated by the word "and," the person is not in possession.
All persons not in
Possession.
Show us a statement in your pleadings that these persons who are claiming mutations are not in possession.
They are absolutely not in possession. They are admitted fact.
Show us the averment in the pleadings. From the pleadings, can these persons are not in
Their
possession of
pleadings.
the land? And therefore, this court, this settlement officer has no jurisdiction to decide this issue. Please refer it to the court.
It is admitted fact, my lord.
Admitted, sir, from
Their
where?
pleadings, I'm showing.
Yes, we are not in position or they are not in position. Show us a pleading, a single whisper in your.
That's
Yes, that these persons who are seeking cancellation of allotment, they are not in possession and they are seeking title over the land. So please refer it to the proper court and you please don't decide it.
Just a minute, my lord. Any pleadings?
Not there.
Their revenue appeal. Their revenue appeal themselves say.
Show us. Show us. Is there any averment on your part that you are not in position? Or their claim that you are not in position?
No.
Are you sure?
My lord, there is no averment because from the very.
Are you sure?
My lord. My lord, I take your lordship only to one page, page 69. My lord, how illegal is that? Oh, my lord, that put initially one question, that whether they are challenging the sale of Manwar Ali or the present epic. My lord, initially put one question, the question was with regard to Manwar Ali or the appeal. My lord, at page 69, my lord, which of page
69.
69.
What is it?
My lord, this is the Jamabandi, my lord.
Yes.
On 3/6/2005, this Manwar Ali name was recorded in the Jamabandi. My lord, page 69, I take to lordship to column number 6.
Yeah, read.
As per order dated 13/8/2003, passed by the circle officer, the name of Muhammad Manwar Ali, son of Mohsin Ali, has been mutated and corrected in place of Patara number 4 to 11 by virtue of purchase and possession. I don't make kindly see purchase and possession, not because. Purchase and possession in respect of land measuring.
No, wait. This one second.
Yes.
Manwar Ali, son of so corrected the name of by virtue of purchase and possession in respect of land of the,
Yes,
yes.
my lord, may kindly see the date below 3/6/2005.
Yeah.
Right. Then, my lord, there, column number 9.
Yeah.
My lord, now the column number 9 is with regard to the appellants here. As per order dated 19/3/2004, passed by the circle officer, the name of Mustafika Hussainara Begum, wife of Abdul Samad, 25, and Mustafika Hussainara Begum, wife of Muhammad Hamidur Rahman, has been mutated and corrected by virtue of purchase and possession in respect of land measuring 2 bigha 2 kotha 12 desa out of total land measuring 5 bigha 1 kotha 8 desa under dark number 146, 149. That is also on the same day, 3/6/2005. These sale deeds were executed prior to coming of the name of Manwar Ali in the Jamabandi. Interestingly, the name of Manwar Ali and the appellants herein, name also came in the Jamabandi on the same day they were corrected, 3/6/2005. The level of minor irregularity charge.
Absolutely incorrect statement made by my sister. Because, no, it is a note of the corrected person. The mutation was done on 13/8.
My lord, corrected. Mutation was done, my lord, it was recorded in the Jamabandi. And they are
Oh.
no, my lord, they have the persistent position. They have never challenged the Jamabandi, they have never corrected. And this sense.
Yes.
Yes, we have a statement.
Yeah.
There. Paragraph, page 43, ma'am.
43. Yeah.
And so from our position is concerned, in reply affidavit, they have not challenged.
Sir, what we are asking, you are raising for the first time here, you show us from the pleadings before the lower courts that you have ever pleaded that these persons were not in possession and therefore these proceedings, you please don't decide these proceedings and refer it to the proper forum.
So for the, before the ADC, before the additional deputy commissioner, that objection we have not placed here.
You have raised the point here, because since they were not in possession, and therefore the settlement officer was not supposed to decide the question of mutation entry, and the proper course for him was to refer it to the.
Correct, my lord.
So show us one statement where you have said that these persons who are challenging the mutation entry are not in possession and therefore please refer it to that proper forum. Show us the
In read petition, I have said,
read
but.
petition, forget read
Yes.
petition, sir. Go to Assistant Commissioner and Board of Revenue.
Lordship, we have filed an objection before the revenue authority that of no annex. Lordship may kindly have to take a time. We have to file it because in the objection.
Sir, now it's not a hearing, please.
But that objection, Lordship's query to answer that.
Show us from this statement. This is not.
No, here, our objection is been annexed, my lord.
Not annexed. We are not convinced. Not at all. And whatever it may be, the concurrent finding of the three courts. That's all. Unless there is.
Our objection, we may allowed to file, my lord. We at the initially at the.
Two mutation entries on the very same day.
No. One is on 13/8, another is 19/3.
Sir, page number.
That I understand, my lord. That was corrected. In the revenue records, the mutation order is different. But it was entered when correction was made by the revenue officials, then it was,
After the order passed. by the
yes,
settlement
absolutely
officer.
correct, my
Is
lord.
that date is.
The date is there, my
3605.
lord. I am just showing.
Date is.
Yes, yes.
3605.
Lordship will kindly have a look at page 69. As per order, 69, my lord. As per order dated 13/8/2023, passed by the circle officer, the name of Mohammad Manohar Ali, such and such mutated. Then Lordship kindly have a look.
On the basis of by virtue of.
By virtue, mutated, corrected in place of such, by virtue of purchase and possession.
No oral date mentioned.
That is the incorrect.
भूल गया वो लिखना क्या होगा.
Lordship was, that is what is there, I cannot correct it. This is a recorded by the, who has.
Your whole case is that land was gifted to you through oral gift.
Now,
And there is no mention about it.
not to me. But my lord, my only question before this, the issues before this on court is that I purchase, I'm a bona fide purchaser. I purchased by 2 sale deeds on a consideration, and without challenging the sale deeds, they only challenge the mutation. This they cannot. And therefore,
Yes.
the possession, as per the land revenue regulation, the mutation was granted on the basis of the deed and the possession.
So if you have any title on the basis of the registered sale,
My lord.
please approach the appropriate forum seeking a declaration in your favor.
I'm in possession, I have a sale deed, why I should approach?
Yeah, no, then be happy with it. Then be happy with it. You are in, on the basis of these registered sale deed, if you are the owner of the land and you need not to approach any other authority, it's okay then.
Time.
How this mutation entry, even if it is cancelled, how it will affect you? Why you have challenged this? Since you are saying I am this, on the basis of this,
My respectful
registered
submission,
sale deed, you are the.
my respectful submission before your honor, before lordship, that the appropriate courts to be adopted by the revenue authorities to refer the parties to the civil court.
That's why.
That clarification.
Says and
Ah.
all persons not in possession.
Yeah.
So where
Yes.
is that finding that?
And ours.
These persons who have challenged the mutation proceedings are not in possession. Show us. There is any aberrament on your part.
Lordship may give us a 4 or 5 days, my lordship. I will. Record is also we also call for.
No, we are not supposed to record call. You
No,
satisfy
no.
your case.
Yes, no,
You
we.
said it.
Respectful submission, give us 7 days time, my lord.
No, already recorded there.
We just pointed out from the record itself.
Whatever it is.
Yes.
You can learn it counsel with the petitioner after attempting to argue the matter for great length. Learned counsel with the petitioner has submitted that since the persons who sought cancellation of the mutation entry in favor of the appellant were not in possession, the settlement officer ought not to have decided the dispute regarding the mutation entry and should have referred the matter to the proper court. Full stop. On a pointed query raised by this court that whether the appellant has ever raised this point that the persons who are seeking cancellation of the mutation entry are not in possession of the disputed land. Learned counsel for the petitioner plays a week's time to satisfy this court that the appellants have, well, appellants did raise the contention before the settlement officer as well as the board of revenue.
If any, my lord.
That
If any.
did raise, you said I raised it.
If.
Did raise.
Because I may made a statement, it was an honorable court, subject to correction.
That the persons who are seeking cancellation of the mutation and mutation sanction in favor of the appellant are not in possession of the land.
Can it be possible on 16, my lord? Now, we'll next week. 16th of December.
16th of December,
In the next,
that is fine.
lordship. Grateful. Great.